number 60, 61, 72 to 74. Well, last week it was appearing as item number 7, 8. Well, I appeared from Supreme Court and your lordship is pleased to give direction. The matter will be appear as to not today. Now what has happened? Well, it is gone down to 60, 61. There is some urgency. Group D post recruitment 600 poster lying vacant. If the posters carried forward to next recruitment process, then our right will go. Some preference.
So if it is not taken up in this week, you mention on Friday.
Friday. Okay, so get.
Your Lordship, may I be permitted to mention one contempt application?
Which bench? This bench, the bench with Justice, Honorable Justice Supratim Bhattacharya. जिस दिन है ना, दिन लगा कल है ना 20th को Thursday, हाँ.
Number 1, my lordship, I beg to appear for the petitioner. My lord, the service is not complete. Service is not
required. Let's see what is the issue. When the recovery was made?
My lord, honestly speaking, I have not gone through. Today I have got the brief. I have not gone through the brief. My lord, I am begging for a 1 week time.
No, 1 week. Come tomorrow.
My lord, I'm for the stage.
He has not read the brief. Let him read the brief. He has not read.
Number 2.
Malad, item number 2, I beg to appear for the petitioner, Malad. Malad, this is for the compassionate appointment, Malad. Malad, but today, Malad, I'm not having the brief, Malad. If your lordship may kindly take it tomorrow, Malad, I'll be ready, Malad, with the brief, Malad.
Spending
Malad, petitioner is the daughter, Malad.
On income ground, it has been rejected, Malad. There is a rejection order. What is the date of the rejection?
Malad, page 48.
More than 90%.
More than 90%.
Is 48.
Malad, under the instruction of my client, Malad, that it is not more than 90%, Malad. For that, Malad, I want to place the Malad some documents, Malad, if your lordship kindly allows, Malad.
More than.
If your lordship may kindly takes, Malad, the matter tomorrow, Malad, I can, Malad, suffice your lordship.
Yearly income. Group D. I both Group D also.
Only not today, Malad.
Sir, you are seeking an employment in place of your mother.
Malad.
Yes. Your father is a government employee. And you are claiming to be a destitute.
Getting pension and family pension.
Under which provision? Tell us.
She is aged about 45 years.
Whatever it is.
Family pension, they getting.
There is no case of loss of sole bread earner. There is another bread earner already. The very concept of compassionate appointment is to mitigate the hardship arising out of sudden loss of the sole bread earner. In your case, you have two bread earners, father and mother both. One is still alive.
Serious, give a part. Sir, that's good to have to serious.
Malad, I'll suffice, Malad. Only 1 day I am seeking accommodation, Malad. I'll come tomorrow, Malad. I'll suffice, Malad. Only not today, Malad. since my lord I'm not having the brief today, my lord, I'll suffice your lordship.
Not today.
Extremely grateful.
No, no, not today.
Number 3.
Wait, please, Your Lordship. But I may be agreeing with the offer of this matter. Not be written that is submit the service upon the concerned spouse. The fiduciary services board, so are in force of it, but within an hour. But what is actually happening happens to be not a senior Ayurvedic doctor. And the service condition is that the contractual service will be up to our basis in age of retirement is 60 years. But in other contracted with the similarly placed doctors, the age of retirement is 64 years. And we are being agreed by that will be
You're claiming parity with whom?
parity with the Gram Panchayat our doctors. Lord, that is a page your lordship will kindly turn to page 34. Page 34, paragraph 3. The application has been filed and the date has been given 27 January.
Your claim was considered by the authority.
Nothing happened.
What is your date of superannuation?
16th, just a minute, 16th of August. I've already been superannuated on 16th of August.
What is the date of filing of the OA?
Has been filed on 23rd of June. That the lordship will formulate
You have to go before the Honorable Single Judge Bench.
your lordship direction, certainly I'll go,
Yes, the same order we are passing.
my lord. Given the judgment in a number of pages, and the Tribunals Reforms Act has come. Unless there is proper staffing, the judicial officers is there, then administrative officer is not there. The same thing is happening in Arbitrary Tribunal. Who will reform the?
Call the next, yes.
Number 4.
Much. But affidavit service will be filed.
Yes, affidavit of service
It
taken.
is being made ready. My learned will be filed.
Why, sir?
Because he's on the way, my lord.
Huh? Let's see, let him come. Very well, not today. Call the next.
Number 5.
My lord, Colwell was in this matter and he has legs in another court, so kindly grant short pass over.
Number 6.
Chandri Alam in this matter, kindly not to say.
Number 7.
কেন আবার আমাকে আনা হতো আমি মানে
তুমি আমাকে শুয়েছো
চেয়েছিলাম এখান থেকে সরে যেতে
But I have for the respondent. Oh, first time before you.
অলসো ফার্স্ট টাইম কি কোনটা করেছেন আমাকে দেখ And I think an application being can number 4 of 2026,
There is an order at page 22. The review. This Miller, I find that he had taken out an application being CAN4 for perjury committed by respondent NTPC. And Miller, at one stage it's my ill luck that I was appointed as an amicus. Then I discharged my duty and the Honorable Division Bench Miller was pleased to comment that since I was siding, therefore I'm not interested to appear. However, Miller, since your lordship directed, I had to appear. Now, Miller, the only thing I say, Miller, that very respectfully that I am told that the matter traveled up to Supreme Court. Now there was the matter traveled up. The matter traveled up to Supreme Court. Then the point of territorial jurisdiction was taken. Now,
What was the substantial matter in issue?
the substantial matter was, Miller, an order of uh, order imposing punishment. A premature retirement. However, Miller, the question came up for consideration as to whether this court has the territorial jurisdiction or not. The matter then traveled, Miller, after a substantial number of litigations, Miller, which were raised by the personally Miller, the client. Then the matter traveled up to the Supreme Court. The order to the Supreme Court. Now, your lordship may kindly consider the order which was passed.
18/5/26.
This order was passed on 18/5/2026. Yes. Now, the Miller, kindly see paragraph 10 and 11 and 12. পার্জারির জন্য কোনটা ইয়ে করেছেন যে কোন জায়গাটা যে
So 9(1), 2), 3 has been complied with.
9.
Paragraph 9, subpara 1, 2, and 3.
Yes. Partially, I am instructed that it has been partially complied with.
So there is no grievance as to that.
Now he has essentially, because I was asking him that why you have filed this application. His grievance is that for perjury committed by the respondent, why perjury? Because your lordship may kindly consider that Miller, this particular order which was passed in the in the particular application, this is also Can 4 of 2026. This is,
No, before we see whether a
Yes.
perjury is made out or not, the
Yes.
primary issue which will arise is
yes,
when an issue is settled up to the apex court
yes,
and paragraph 12 says any other grievance.
yes.
You please see the expression used by the apex court in the second line of paragraph 12 for any other grievance.
Or any other grievance by the.
Yes, so what the issue, it appears what the apex court wants to say or wanted to say is that now he cannot be, faced with an issue of territorial jurisdiction in
Absolutely.
Kolkata
Absolutely.
because he is a retired person, he is there to take up whatever grievance he has.
Yes.
Now, going back and looking into a perjury in the proceeding which concluded up to the Supreme Court, can we do it here at this?
Kindly consider one thing, that so far as the particular Millard, he was facing a initial countenance from the court, that was whether the court has a jurisdiction, because if the court has jurisdiction, then the court will be deciding the merits of the matter. But the merits of the matter was not being touched on the ground that there is no territorial jurisdiction. Now then Millard, he was, rather I should use this expression, that he was a disgruntled Millard litigant. He then himself went to the Supreme Court, appeared in the matter, court passed this order.
So the substantial relief sought in the writ petition was allowed.
But no,
And as regards territorial jurisdiction, instead of
Court-
striking on the order, the apex court said that he is a retired person, now don't issue representation of jurisdiction, you decide whatever other grievance he may have in relation to his termination.
Right.
So therefore, in that proceeding which has concluded by an order of the apex court, can we look into at the high court
now
whether
Millard,
there is a perjury or not?
now
That's
Millard,
the
your
primary issue arising.
Lordship may kindly consider that so far this order is concerned, for a second, Millard, your Lordship may kindly peruse this order. This order of 27th of February 2024 passed by a division bench of this court.
That has already merged in the apex court's order now.
Now Millard, the question of merger,
Uh,
your Lordship is indicating that Millard, this has merged into the order of the Supreme Court. Therefore, Millard, if your Lordship is of an opinion that
No, we are asking you to, you are asking your assistance, whether at this juncture we have
I say, Millard,
an
that for
option to,
any other grievance, this expression which has gone down into the paragraph 12 of the order of the Supreme Court.
because you see paragraph 9, the line says, having considered the matter,
Yes,
the present petition stands disposed of.
yes.
That issue is over. Then
Millard,
it says in these terms, then in para 10, it even dispenses appearance of the party who had been asked to appear for ensuring compliance or granting relief to him. In paragraph 11, the apex court says that he says, I am a retired person, this financial burden I cannot take anymore. Supreme Court has said that now on, for your grievances, including a grievance of termination or any other grievance, the Calcutta High Court will have to consider it without raising an issue of territorial jurisdiction. But we are not deciding any other issue. We are being called upon to examine the proceeding which concluded and was disposed of by an order of the apex court. Because if we find a perjury, then the outcome will change. Can we do it?
No, I say, Millard, if your Lordship, Millard, compares para 9 with para 12,
Yes.
kindly see, Millard, what will be the legal consequence.
Please, yes.
Para 9, Millard, had indicated that the present petition stands disposed of on the following terms. This
That
has been,
terms,
now your Lordship is indicating that having considered the matter, therefore the court had the occasion to consider the matter and pass an order. Very well. I say,
it
Millard,
is
that-
explicit.
no,
It's not an
Millard, I cannot say anything more.
Needs
But
no
only
interpretation.
thing I say, Millard, subject to correction of my lords, that Millard, this paragraph 12, then Millard, that if a petition is filed for any other grievance, then this particular thing becomes an ocious. Otherwise, Miller, this is clashing. I say, Miller, with the greatest of my respect, this is clashing. Now, for this thing, Miller, he had filed this application. Now, subject to what falls for Miller's kind consideration. And Miller, the paragraph 11 also kindly.
So what you so what you there is a direction from the Honorable Episode, page 21.
Page
21.
paragraph 12. Paragraph 12, yes.
Paragraph 11.
Yes.
He may be granted liberty to approach the Calcutta High Court for his grievances with regard to his termination from service.
Yes.
So this is an opportunity given to the litigant to approach this. Why not the court of the first instance? It should be the court of the first instance subject to
Yes.
action.
Yes. Yes.
Then how this can be agitated over here in the division bench without
Millard, I had asked him that why did you approach the Supreme Court? The answer which I got from him, Millard, because he is there, because I should, Millard, whatever I submit, I should submit after obtaining his instruction. Now, I am told, Millard, that for the purpose of settlement of the terminal benefits vis-a-vis the jurisdiction of the court, because the countenance from the court was that this court has no territorial jurisdiction. Therefore, as a consequence or a corollary, he cannot get it.
so therefore the entire things boils down to the honorable civil judge. The honorable civil judge initially passed an order to complete the jurisdiction.
Yes.
So today if you have any grievances in respect of the same, then it will be the court of the first instance.
Yes.
Then how this application can be enacted?
Millard, I would be only submitting that, Millard, your lordship may kindly consider paragraph 12.
Yes.
If your lordship, Millard, peruses paragraph 12.
Only the Calcutta, that is why the Calcutta had a jurisdiction to
Right.
consider the same.
Right.
Then why the division? Why not the court of first instance?
So the order was passed by division.
Millard, your lordship may kindly consider that the initial order was passed, if I may say so, with my
By
greatest
Justice Sivaganam, as his lordship, there was sitting with panel justice.
Your lordship is indicating that why the division bench and why you are not going before the single bench. That is possibly the
Yes,
query
yes.
of the court. Now, your lordship may kindly consider.
The order was 22. This order was passed by division.
Millard, I am being instructed that an order was passed by the division bench. Now, I say, Millard, I leave it to the court, because in any event, this matter will up to. I say, Millard, with a very candidly, I am speaking one thing.
My query,
This matter will travel up to again the Supreme Court. I know. Millard, this I should say, Millard, this is although Millard,
He is
this-
alleging a perjury before the division bench or before the single judge bench?
আপনি কার কাছে পার্জারি দিয়ে করছেন?
Division bench.
Division bench. Because the order was passed by the division bench. What was the perjury? The perjury was that the authorities made a submission, which I find, Millard, in the order of 27th of February 2024, that, Millard, there was a direction that NTPC shall file an affidavit disclosing all documents. Millard, this is an affidavit.
R16.
Millard, this is an affidavit in opposition of respondent number 1 to CAN 4 of 2026.
Yes.
Now, this is at page 22. I asked him that what is the reason that you are taking out an application for perjury.
That day you were appearing, yes.
Now, I was not appearing, I was told to appear. Kindly, I say, Millard, again, Millard, I am submitting with a great caution that I do not intend to appear in the matter.
So what is the perjury?
Millard, in para 3, there was a direction that the NTPC shall file an affidavit disclosing all documents and minutes of the meeting of PMC Taki
Performance Management Committee.
of Performance Management Committee for performance of the petitioner in 2015 and 16. As we are all of the view that the reason for reduction of the petitioner's marks in the appraisal reports of 2015 and 16 is required for consideration. Then Milord, ওরা কোথায় বললো যে আমাদের কাছে আর কোনো ডকুমেন্ট নেই, সেটা কোন এফিডেভিটে?
Can 2 of Mac. Can 2 of Mac.
So they did not comply with this order.
Yes, Milord, what happened, Milord? They
You
made a
against
statement.
You against Can 2, page 110 of.
I am told, Milord, that
You against Can 2.
at an affidavit in opposition against Can 2 of Mat 2362 was filed, wherein a statement was made that this is not available with them.
In the opposition, they have said, where is that?
That, Milord, your lordship may kindly consider. এটা কোথায় পাবো?
এটা পাবেন আপনি page 48 of COD compilation of
Milord, there is a compilation of documents,
page 48.
compilation of documents, Milord, at page
48.
48. What he had done, Milord, in order to shortcut the matter, Milord,
We have it. I'm sorry to interrupt. Since I feel that my learned friend is really not very aware of it. Kindly, Honorable Supreme Court has said that your chapter of termination is concluded. You have retired. If any other grievance post-retirement.
No, no, the termination is left open.
No.
Termination is not concluded.
Absolutely. Kindly comes to me.
Please see paragraph 11.
Yes, yes. That is open, concluded. Kindly come to me, Lord, the order, page 2 of the order. The controversy revolves around the fact as to the amount which was due to the petitioner, either towards his provident fund contribution or with regard to the benefits post-retirement he would get from the EPFO. Today, the court has been assisted, and upon confirmation from the petitioner, it appears that the EPFO contribution of the petitioner is being regularly forwarded to the EPFO. However, with regard to the provident fund, which is also normally maintained, so and so, I am not troubling my lord. An offer has come from the respondent number NTPC that the EPFO has a scheme under which a higher rate of monthly pension is available to a pensioner who agrees to contribute higher fund, EPFO contribution. Petitioner was also asked for the same, and a specific reply has not come as to whether he would himself pay the amount or from the amount which is lying in the provident fund account in favor of the petitioner, the amount to be transferred. At this juncture, on the query being made to the petitioner, he submits that the respondent NTPC may directly forward the amount which the EPFO requires for the entitling the petitioner to a higher rate of monthly pension. With regard to the remaining, he submits the same as to be given to him. Therefore, all grievance was that retired, now pension. Now, having considered the matter, Lordship may not be troubled with para 9. Then kindly come to Lord. At this juncture, after that everything is over, so guys, amount of computation and everything, that the main reason for him to approach this court in the present petition was that the writ petition filed by him before the Calcutta High Court was rejected on the ground that the court had no territorial jurisdiction. It was submitted at now when the petitioner has superannuated. And the respondent number 1, NTPC, has an office in Kolkata. He may be granted liberty to approach the Calcutta High Court for his grievance with regard to his termination.
So therefore, termination was an issue left open.
May I just complete?
Yes.
Termination from his service, he is settled in Calcutta. Then, in the facts and circumstances of the case, we observe that if a petition is filed for any other grievance, not termination, by the petitioner against the respondent number 1, the same shall be heard on merit. Any other grievance which is post-retirement, include the termination has gone, the court did not say the termination will be agitated because he stands retired.
okay.
And now the grievance which is being sought to be made is relating to the proceedings which related to without.
So therefore, we are on that primary issue. All this will come later. How we can look into an issue
That's
which
the
has
point.
attained finality up to the apex
That's
court.
my point, my lord, that probably court will be very slow to pass any order in this petition, because this
If at
petition,
all he is of the view that some perjury was committed in that proceeding, it was for him to raise before the
Yes,
Honorable
yes.
Apex Court. If he has not done so, then can we now reopen?
cannot. Now, he can complain that even after retirement, my amount of pension which was sought to be paid by the Supreme Court is reduced or not paid. Anything post-retirement can be done
We
here.
appreciate what you are trying to submit, but whether we'll go into an interpretation of an apex court judgment
No, my lord,
when it takes note of his submission regarding termination, whether we can limit or we can interpret this judgment in any way or order in any way, that is another issue.
that's different issue.
That's a
But to
different
me,
issue.
because this application is not maintainable before a lordship.
On the ground of maintainability, therefore, we were requesting the learned senior advocate if he can assist.
Please, little embarrassed. It appears from his body language. I am not making any comment on that.
No, see, an issue is there. There's no question of embarrassment. We appreciate and we really appreciate the appearance.
This matter went from one bench to another bench, another bench to another bench. Everybody was sympathetic because the person was appearing in person. Thereafter, he was forced to hold the brief as our curiosity.
No, it only facilitates from both sides, for the petitioner as well as the court. Because the dispassionate approach is required to some issues
Yes.
which cannot be done by a person appearing in person,
You will be
a
emotional.
litigant appearing in person. So dispassionate at the same time taking up the cause with. So we appreciate his appearance. We are not on that.
So therefore, Lord, this is my submission. I will take leave, Lord, having someone in Chief Justice Court.
Please go.
Only one thing I will be indicating to my lords. Kindly see paragraph 11. After 4 lines. Paragraph 11 after 4
Just
lines.
before we proceed,
Yes, I'm sorry.
can you please show us what was his substantial prayer in the High Court? In the writ petition, what was the substantial prayer?
I have to take all assistance from him.
Please take your time. We are not in any hurry.
Petitionটা আছে? রিট পিটিশনটা আনেননি কেন? না ওইসব মুখের কথা হবে না, কোর্ট যা চেয়েছে সেটা করতে হবে। এক সেকেন্ড দাঁড়ান।
Solve the reports. They said we don't have the report, which is false. Then subject matter. The issue is that any court below the apex court can consider that this is our single bench. That's not clear. If the issue is concluded and everything has finally been decided by the court of the apex court.
Yes, can you?
Millard, I am told Millard that he did not bring the writ petition.
It's not there in this voluminous paper book.
It was only made for jurisdiction issues. So the original writ petition is not here. It was
How
only
it
for
can be?
jurisdiction issues, and it was not subject of this. Actually, the writ application was there along with this file at that time.
Writ record is the writ. Oh,
রিটের ফাইল তখন ছিল।
তখন ছিল writ file এখানে লাগানো ছিল।
Matt, the writ record, where is the writ record?
এখন সরিয়ে নিয়ে আলাদা করে দিয়েছে ওটা। And at that time, the writ was application was attached to this one, this particular one, before the honorable division bench.
WPA number.
হবে না, রিট আনতে হবে। But I can come, Millard, any day if your lordship directs. I have nothing to it. Because writ petition I do not have. Only one thing I just showed to my lords.
Paragraph 12.
paragraph 11.
11.
Paragraph 11 and 12, because paragraph 11 after 4 lines, just kindly see. I say, my lord, this order is very confusing. As an officer of the court, or I know that even my lord, as an advocate or as a senior advocate, I cannot make this submission in a court in respect of an order of the apex court. I know. Rather, this will be against the judicial propriety. Kindly see the particular after 4 lines. It was submitted that now when the petitioner has superannuated and the respondent number 1 NTPC Limited has an office in Kolkata, he may be granted liberty to approach the Calcutta High Court for his grievance with regard to his termination from service since he is settled in Kolkata. Therefore, again, I can approach the court with regard to the termination issue. And then in paragraph 12, this was commented that if a petition is filed for any other grievance by the petitioner against the respondent number 1 NTPC, the same shall be heard on merits. Therefore, the entire matter was again left open to the Calcutta High Court.
Before we embark on this exercise, is an order of the apex court subject to interpretation?
Not at all.
So it says it's.
So say, Miller, that as an option.
So we are not on that. We just want to see what was the substantial relief. What is the substantial relief? You please show us whenever you want this week.
Miller, the substantial relief which he wanted is
From the writ petition, when can you bring it? Tell us. So that will only reveal what.
yes,
As per your convenience, you tell us as per your convenience.
সামনের সপ্তাহে করবেন Miller, any day in the next week.
Let the must be having a copy of the writ.
If myself merged with these particular documents, kindly do not do that. I appeal to my lord.
All right.
Wait. 8.
For the state. नहीं तो
Not 3%. 3%. Let's put that. 7. 7. Right?
Wait for the.
No, Lordship, I am for the Lordship, respondent number 224.
3%. 3%.
Last occasion, Lordship directed the Lordship petitioner to submit the Lordship tribunal application, where the matter is pending or not. About the tribunal.
Accept order. Accept order.
1st July order.
Six. করবে না ডিসমিস করে বলে অ্যাপ্লাই করবে ইচ্ছে খেতে পারবে না না
17. Which then default by any earlier.
39.
If they revise that. Otherwise, we have to find restoration of the.
I'm for the appointment.
And for the respondents, Lord, your Lordship kindly see, Lord, your Lordship's order dated 11th May. That is the last annexure of my application, CAN 3. Lord, there at the relevant time, it was found that no separate application for exercise payment was made. But it was made, not annexed with the documents filed by the appellants. But we are for the respondents. We have made this application that it was filed in terms of the order passed by the learned single judge in terms of order dated 3rd July 2024. And Lord, at page 9.
You made an application after this order.
Lord?
Have you made an application after this order?
After this order.
No, Lordship.
On which date?
This application? No, the application was filed not long back. That is on.
So you are choosing to ignore our order of 11th May.
Your Lordship, it is already there. I just pointing out that it is already there. It was done, considered, and thereafter submissions were made.
Therefore, we are asking you choose to ignore the court's order of 11th May.
No, Lord, I just pointing out that it is.
We are not asking you to point out anything. We are looking at your conduct.
Lord, your Lordship kindly.
After considering things, when we have passed an order, can you ignore the order without seeking a recall of the order or filing an application in this regard?
Lord, your Lordship kindly see this is already there.
We will not look into it. Why we should?
Lord, upon consideration of this, the
Why we should go back, sir? Why we should go back? Why you are not complied with this order? You are not interested, obviously.
Lord, Lord,
Obviously, you are not interested in litigating than getting any relief.
no, Lord, your Lord,
Please do so.
Lord, kindly see, my Lord, what happened. Lord,
We will not see why you have not complied with the order and why you have not filed an application if you thought it not proper to comply with the order.
Lord,
Answer that only.
Lord, I have made this application.
Please show us any application filed after administrative either in compliance or for modification of that order.
Lord, that is this application.
Which application?
This application I am made before your Lord.
Can number?
See. That's why Lord made an application. It is already there. It has been considered by bank. Thereafter, made application for the last signature. Accordingly, the impugned order was passed. It was not found by your. It could not be found because it was not annexed. It is their appeal.
You have made an application.
Yes.
Where is that?
Yeah, not Lord. Compare it.
Yes, what is your instruction?
Chief, our suggestion is that by the respondent, right, submission holds, proceedings, our company
Can you see page 8?
should therefore seek to
Yes, you should file an opposition. We are also happy. Let an affidavit in opposition be filed. Call the next case. We can also understand what is going on.
Item 10.
Must have got the somebody is looking for the extra because you see the order I have said that all the details are not that means it was not in the performance solicits on process. They cannot disclosing of performance. Some other
that? Get in here. And that passing also. Yes.
Item number 10, my lord, Ms. Purvi Das is appearing for the appellant. My lord, she has been hospitalized, my lord. She is suffering, my lord, from a fracture in her leg, my lord. If your lordship kindly keeps it after 2 weeks.
We're informed.
Your lordship, I am appearing for the appellant bank. I am led by Mr. Shoptangshu Basu Lanet, senior advocate. He is engaged before Honorable Court number 12. Your lordship, I am praying for a short passover.
Let's see. You file your opposition.
I have given them Lord in copy.
We have served with copies. Your
So file it, we'll adjourn it.
Lord the very small submission. Lord the by the order impugned. Lord the learned or Lord this honorable single judge has directed the authority to pay me all my post-trial benefit, because Lord I was put under premature retirement. This order is challenged before your lordship. Lord, by showing pendency of this appeal, Lord, my entire service benefits have been withheld. And Lord, this is the
Pensionary benefit, not service benefit.
pensionary benefit, post-trial benefit, Lord, has been withheld.
Yes, so we file it. There is a premature retirement by virtue of a punishment, by way of punishment, not simply sir. Not with pensionary dues.
No, Lord, simply sir.
It is a punitive order according.
Yes, your lordship.
After an inquiry.
Lordship.
Lord,
After an inquiry,
Lord,
my lord, the honorable single judge, my lord, was pleased to pass the order merely on the basis of, my lord, 2 grounds. First, my lord, for the charges, the second time, the charge sheet was not provided to him, my lord, although it was, my lord, from the records we will show. And the second thing was that there was a delay. My lord, the plea that was taken by the petitioners was that after 2 successive audit intervals, the inquiry cannot be started or the petitioners cannot be hauled for a disciplinary proceeding. Well, they have taken shelter under a particular memo. That particular memo, my lord, says that there will be an exception where, my lord, there is a fraud and vigilance angle to it. That is why we have filed, my lord, our application under Order 41, Rule 27, in order to show that yes, there was a fraud angle in respect of those accounts for which the petitioner was charge sheeted. Well, the charges against the petitioner were at the time of sanctioning of the loan, my lord, he did not take the proper due diligence, and my lord, the records were not clean. My lord, those accounts later on turned into a non-performing asset, and my lord, the bank has suffered punitive losses, your lordship. Against that charges, my lord, the disciplinary authority has punished the petitioner. My lord, they have come up.
No, Lord, this is not the correct proposition of the Lord the judgment,
My
Lord, because the honorable single bench has been pleased to set aside all the judgments.
So every line she submits, you will give a reply. Please do so. But don't expect us to understand what is going on. You can do so. Yes. Yes.
Yes, Your Lordship. Lordship, and from the records, my lord, we will show that the petitioners were duly informed. The petitioner has participated in the inquiry, my lord, without any demur. He has not taken any plea that this particular inquiry is a belated inquiry, my lord. Nowhere, neither in a statement of defense, my lord, nowhere he is taken that plea. The plea has first come up in the writ petition before the Honorable High Court.
What prevented you from placing these documents before the honorable?
Lordship,
Single Judge?
yes. My lord, these documents, my lord, were in the custody of police as well as, my lord, was in the custody of the learned DRT, your lordship. That is why we couldn't get.
There are FIRs also.
Yes,
In
your lordship.
relation to these loan accounts.
Yes. There are FIRs, my lord. That is why we couldn't get the.
Bank has lodged FIR.
Yes, bank has lodged FIR against that loan accounts in which, my lord, the petitioner has sanctioned the loan. So, my lord, FIR has also been lodged. My lord, also there are searching report to that aspect showing that the area which was mortgaged, the land which was mortgaged, my lord, actually never existed. Without the title deed, without proper verification, my lord, the loan was sanctioned. My lord, those documents were not placed at that point of time. That is why, my lord, we have come up with the application to which they have also replied. My lord, this is the case, my lord.
So now the opposition is filed, we can proceed.
Yes, Your Lordship. My lord, I'll just be praying for a short passover since I'm led by Mr. Shopangshu Basu. My lord, he
See the learned single judges order.
Yes, Your Lordship. Yes, Your Lordship. Under the order is very
Any other pending applications?
No, Your Lordship. My lord, only the stay application and, my lord, the present application.
What is can 1 and 2?
Lordship, can 1 was for delay, my lord, which has been can 1 is for the delay, my lord, the delay part your lordship was pleased to allow. My lord, can 2 is the stay.
Allow? When?
Yes. Your lordship's order was there, my lord, before admission of the appeal.
These shows delay of it is yes, can 2 is allowed. Why it is on the list? Can 1 is your application for additional evidence.
Yes, can 1 of 2026. Now every can 1 is can 1 for the year 2006. This is 2026. This is the first can. Can 3, my lord. In my copy, it is written as can 3.
Can 1 and can 3. Why? Who is listed? Oh, there's
One is the stay, I believe.
one is for stay and 3 is for additional evidence.
Can 1 was the stay. Can 2 was for the delay, your lordship, and this present one is the can 3. Lordship will find, my lord, the judge.
Please let us go through the order.
Yes, lordship. My lord, my senior has arrived.
Yes.
So you
Yes.
Madam, read the improved order.
Here we have gone. Yes, we have gone. It appears that the Honorable Single Judge has considered 2-3 aspects, whether a disagreement note was in accordance with law. The final order passed by the disciplinary authority is sustainable on the material in the inquiry. And lastly, an issue of delay. These 3 things.
My understanding, so far as the order is concerned, the court has proceeded only on the ground of delay. If you have understood this order, that is. What is the delay? A notification of this the department has been annexed, showing that after the 2 audit is you cross, then that cannot be a ground for proceeding against you. But my lord is well aware, since vanishing, my lord, these are called stale charges. If the charges are stale,
Punjab and Haryana High Court.
so if for A, B, C, D, these charges are stale charges, so you cannot proceed against the stale charges. The delinquent has forgotten everything. How we can depose? That's the concept.
Yes, Apex Court said human memory is short.
So vanishing also I will rely. I will proceed only on the ground. That's why, my lord, I have filed an order for 27 application.
The order appears to be in 2 parts as we have gone through. The one part is delay, which has been relied upon to set aside the charge memo.
From the initiation.
The other aspect is that the disciplinary authority's action on the inquiry report was not found proper and it was found to be a perverse. So there are 2 findings.
Perverse, my lord, I will demonstrate before my lord whether perverse or not. If the 2 views are possible, 1 view accepted, it is not a judicial authority, the quasi judicial authority will be sustained.
No, there are 2 aspects. It says,
Yes,
the judgment says, firstly, that Kunj Bihari Mishra is not complied, meaning thereby that the disagreement was not by recording reasons, the acceptance thereafter or final order is not supported by reasons based on material, and also findings are perverse. So paragraph 34, 35 contains these findings. Then the court proceeds to consider whether a delay can be attributed or not. The rule says 2 successive audits, if it has gone unnoticed, then it cannot be considered.
Yeah,
And on that ground, it has.
start with the last one.
Yes, you may.
My lord has finished my order for 27 application I have filed. In the reply to that order for 27 application, their contention is that those documents are forged documents, concocted, afterthought. They have not said anything that if documents are correct, which the authority is producing before my lord, prayer for statutory is there, lordship for the entire records and peruse it. They have not said if the documents are correct, then what is the consequence there? They have not said anything. Let us, my lord, try from that angle the document which was subject matter of the honorable single judge to come to a conclusion that charges are stale, so you cannot proceed. So kindly come to 166. 166.
Even, uh,
So for meet which finding of the learned single judge you are filing the application for additional evidence?
That is a stale charge, you cannot proceed. Because, my lord, now, my lord, may I please? Justice, I kindly come to page 166. That's the notification which was went with the court and said, in view of this notification, the charges are stale. You cannot proceed.
That clause 2.8.
166, I come to 166. This is the notification.
160.
Compliance of CBC guidelines. Page 166, my lord, of second volume. Allow me to read with my. The notification dated 10th October 2008. Information required by the board. At the end of every quarter, I and AD has to place a note to board in respect of the confirmation of compliance of the following CBC guidelines. No disciplinary proceedings will ordinarily, I request you lordship to mark this. No disciplinary proceedings ordinarily against an official for any lapses not detected within 2 successful internal regular audits, inspections of the same account of 4 years from the date of event, whichever is latter. In case any irregularity is detected subsequent to the second audit inspection, the auditor inspector concerned will be held accountable and be liable for disciplinary proceedings. In second stage, auditor will be held responsible. Then, this time limit will not apply in a case of one fraud. Documents I have relied in order 1427, it appears that in terms of the RBI guideline, this account detected to be a fraud account. So, either criminal offences, III cases where malafide are inferable. Accordingly, we have been seeking the information on the end of every calculated. Now, information for the quarter ending of offences is placed on board. Please review the disciplinary action initiated during the quarter ended April 2008 and confirm compliance.
Yes.
My lord, and take now my order for 1027. The statutory format is required to be filed before the Reserve Bank of India if an account is detected as a fraud account. Kindly come to page 10. Reported institution Punjab National Bank. Kindly turn over the page. Page 11. Name of the bank Punjab National Bank. Kindly come to 4. Name of the principal party account. The Ships of the Industries.
6A, nature of fraud, misappropriation and criminal breach of trust. Date of occurrence 24th March 2004. He is telling this date. The court is taking this date and thereafter lapses of 2 audit has been crossed. Then date of detection 8th November 2008. Records of delay, if any, in detecting the fraud. Fraud came to notice during checking of securities. 9. Modus operandi. Availment of finance by submitting fake title deed of the IP mortgage. Page 12. 12B. If yes, why the fraud could not have been detected during such the audit? Fraud came to notice during checking of securities. 12C. What action has been taken for non-detection of the fraud during such inspection? Accountability of inspection official is being examined. Then kindly turn. Page 13. II. CII. If not, reason thereof. Whether any claim has been lodged with an insurance company. If not, reason thereof. Insurance cover against frauds not taken by bank. Then my lord, kindly turn over this page 14. Then my lord, kindly come to page 14. Staff side action. Number 2 is before my lord. But so far as number 1 and number 3 proceeded against, dismissed. There is no discrimination at all. There are line of judgments where said if on the same charge one is not charged against. 1 and 3 it was charged. The details of prosecution. Staff side action is being initiated. Staff side action is being initiated. Then my lord, part 2B, additional information on fraud in borrowed accounts. Shiv Shakti Enterprises. Then we'll kindly come to page 16. The paragraph starts with, I do not travel loss in the entirety because according to me it is not necessary. The present incumbent, as Manoj Kali got it. The present incumbent during his visit on 9 December 2007 for checking of securities found that various portion of the mortgage IP is part of lake mortgaged, lake property mortgaged. The other parts are being used by school and a local club as playground. They claim that the land belongs to them. That has been mortgaged. Yes, my lord. These are all part of the annexures which required to be filed before the RBI. So kindly come to 18. The name of the party is Shiv Shakti, Kolkata. Kindly come to 6. Nature of fraud. Title deeds fake one. Title deeds fake one as per panel advocate Rajgopal Mitra.
Yes.
Then, my lord, these are the instances, my lord, this is the statutory format which requires to be placed. Page 19, my lord, reason for delay. That is also, my lord. He then, branch manager, informed that and
Then BM informed the fact to the authorities and FIR was lodged on 10/11/2008.
One date may be necessary for your lordship, my lord, when the charge sheet was issued. Page 146, I am giving the date. On the 30th July 2010.
Charge memo.
That's the initiation of the proceeding within 2 weeks, 2 years from the date of detection of fraud. My lord, can we go back to page 19? Clause 9, brief history. Title deeds being number such and such, mortgage with the bank is a fake document. And panel advocate such and such. In every page, my lord will get that. Why? This is a fake document, fraud, and when it was detected. Kindly come to last of page 20. Details of staff side action. Staff side action treated against C. Panchanan Mal, and the other two names are also there. Departmental proceeding has been initiated or not? Inquiry page 21, my lord, got it.
Yes, yes.
My lord, I cannot read, my lord, I cannot request your lordship to read. Departmental action was taken against Panchanan Mal and two others, that is there I have shown to your lordship.
Departmental action is initiated
Yes,
against Sri PM Lal and then the then senior manager,
Yes. I have shown to you 3 persons were there.
in whose period the loan is sanctioned. Since the property mortgaged is is land under deep water and occupied by school stroke club.
School authority that I have shown to you lordship. The water body has been mortgaged. Now, my lord, kindly turn to next page. The FIR was lodged.
What is the PS case number? Can you find the PS case number anywhere?
This is 10/11/2008.
No, PS case number.
Page 22. FIR against the Mohesh Chancellor Shiv Shakti. By relying on these documents, my lord, I want to canvass before my lord that the CBC guideline, which is the subject matter of giving the weight.
This is covered by exception in that guideline. This is what you are trying to say.
Not only exception. Exception is 3 categories. One is fraud, high or teaching.
Correct. Whatever.
And I will rely on my judgment of the apex court where says the bank employees should be treated not at par with the other employees. This should be highest pedestal. If there is a likelihood of loss to the bank, proceeding can be initiated. Likelihood. So kindly, correct, madam. The charge sheet with the other officers are also annexed.
That's not required. That is not required.
Why I am saying he is not in isolation.
So what? We have to see his case as per his own case. What they are doing, they are taking it, accepting it, not accepting it. How he can be guided by?
Why I am saying this, my lord?
I have shown that
I am preparing for the authority.
you have shown that you have submitted that you are maintaining a uniformity. The 3 persons who are responsible, the report says to proceed. They have been proceeded again.
That I am submitting.
That sufficiently you have made out that point.
Substantiate that I have annexed here.
Very well.
That he is, if a fraud is detected,
Issue still will arise whether even if it is against all 3, whether it can be done or not. So substantially we have to see the CVC guideline and 2.8. These 2 provisions.
so according to me, according to my humble submission, if the documents which are before my lord, and he has said these are all 4 documents out of the story, if it is not, my lord, I have a case to wriggle out my client from the ambit of CBC guideline. Basically, come back. Now only left out is disagreement. I don't know about it is nothing new. In civil jurisprudence, trial court must defeat the suit. Appeal court reverse it. Two modes is possible. One is why you are disagreement, you are there, you have to record that. But if the lower I cannot say now. The appellate court is of the opinion and independently scan the evidence and come to his own finding. Can it be said that he has not performed his duty? I'm asking the question to myself. He has not in so many words says for A, B, C reason I am in disagreement with the finding of the first court. But he independently scanned the evidence and come to his own finding. According to my humble submission, is tantamount to reversal of the finding of the honorable first court. Will under first court. Yes. Now, my lord, I will request your lordship to see side by side what is the charge and what is the independent finding after the disagreement. Now, kindly come to page 143 of your lordship, please. The charges. I find articles of charges are 1, 2, 3, 4, 5, 6, 7. But while disagreeing with the finding of the first authority, he has taken care of the my lord statement of imputation of misconduct, which of my lord under 1 there are 6, under 2 there are my lord 1, and under 2 there are 1, under 3 there are 4. So he was carrying the evidence in respect of the imputation of misconduct, not only the charge sheet, which is elaborate. Charge sheet ballot is composite, imputation of misconduct is little elaborate. Now, my lord, let us come to the imputation of misconduct at page 140.
One 143 is the disagreement note.
No, 143 is the charge sheet. Disagreement note is at 284. Unless we, my lord, hardly go through the charge sheet, my lord.
Yes, yes. Just give us the page number of disagreement note.
Disagreement is 284.
Very well. Now you proceed.
The functional manager office or one while working as senior manager at Leo Gorakhpur have committed the following. Article 1. The account of Mr. Plastic supplier Sri Mal committed various pre-sanction, post-sanction lapses. Tax interest. In use of funds was not verified by him and Article 2. While sanctioning of Samal Malki and Sujoy not ensure that scorecard was not approved from the authority and did not ensure that the selection of promoters and the borrowers were prudently done. Loans were disbursed before completion of the CAT to the authority. The borrowers are defaulted in the payment of the installments. Article 3. In the CC account of Majmuki traders, he committed various pre-sanction, post-sanction lapses, irregularities, jeopardizing bank interest. He sanctioned the loan despite unsatisfactory conduct in the current account of the party. He did not show normal prudence in such sanction when the sister concerned were also operating from the same premises in a similar stock. He did not mention in the process of note how the party did the margin requirement and did not assess the financial statement properly. While sanctioning, he did not properly assess the valuation of the IP mortgage to the bank He did not follow up with the party for deposit of early installments and thus violated his own terms of sanction. 5. The fourth. In the card of sanction to law, it did not ensure that the party submitted bill money receipt for purchase of the vehicles and also did not ensure that joint restriction and insurance of the vehicles were done and kept on record and thus jeopardizing bank interest. While sanctioning term loan to Uttam Saha, it did not ensure that promoter was not approved from the authorities and the construction of the road was completed. The repaying capacity of the borrower was not assessed properly by him. ID return submitted by the party was not properly scrutinized and it did not inquire about the source of margin money. It did not ensure that the same was routed to the bank. It did not make spot verification of the property before disbursement, as there was anomaly as per the sale agreement. It did not scrutinize the title deeds properly, as there was clear tampering of the total areas of the land. Now, my lord, the charge which was fraud. CMAL, while sanctioning facility to Mr. Shivshakti Industries, committed various pre-sanction, post-sanction lapses, irregularities, and jeopardizing bad interests. It did not obtain the financial documents related to the properties of the last 3 years and also did not obtain PR from borrower from the previous bank debts.
What is CR?
Credential.
Credential.
It's very problem. The bank matter is so abbreviation are used.
Yes, bank matter and Union of India matters. The armed forces.
They knows very well. You don't know. I don't know.
And the lawyer also does not take care that at the time of filing they should give the full form also.
Last generation.
At the time of filing, we said at the time.
Can gather from your lordship's brother. Because it is difficult. And my lord can recall just Justice Rai has come. Justice N.K. Mitra was there, late Justice N.K. Mitra. Somebody is saying, I am taking 2 minutes time. My lord, I have sent. My lord, I have sent the postal remark, postal envelope, but AD has not come. Judge will see, look up. He will not look at you. The new person will not understand why the judge is looking at him. Somebody from outside say, don't say AD, say acknowledgement due card. My lord, acknowledgement due card has not come. Oh yes, say so. We have learned of that. Like AD. The sanction ad hoc limit in the account much beyond his vested powers and also did not move for information of his action from the controlling office. He did not ascertain that his transfer made from the account were for genuine trade transactions for which the loan was sanctioned. Despite irregularities persisting in the account of the enhanced limit of the account, he obtained collateral security of IP in the account without conducting pre-sanctioned visit to the property. As subsequently it was found that it was found that the same does not belong to Shivshakti Industries and where a lot of discrepancies in the character of the land is observed. Thus, chances of recovery in the account of the sale of mortgage IP are remote and bank funds are jeopardized. I have shown to lordship the fraud, how it has been conducted. Sri Mal, during his tenure as senior manager at BO Paksakas, Calcutta was committed several irregularities in respect to area, house building loan accounts. Altogether, 7 loans have been sanctioned with rupees 96 lakhs for purchase of flats in the same building, and all have become NPA. In almost all the cases, the verification report is not made. Accounts were included from the very beginning, and discrepancies in the documents like sale, deed, possession, letter, etc., authority of transaction of Thus, the bond failed to take all possible steps to ensure and protect the interest of the bank and failed to discharge its duties with utmost devotion, diligence, honesty, and integrity, which constitute misconduct in some of the regulation C1, read with regulation 24 of the PNP officers employees. 7.2 regulation. Copy like
No, that was in the earlier point, 2.8. Some provision 2.8 was also considered on the issue of delay.
Delay.
Yes, on the issue of delay, apart from the CBC guideline, 2.8 clause 2.8 is also considered. It is taken note of by the learned single judge.
I will rely on punishing, where it says the delay alone is not fatal. But I will come out on that. If I can overcome one of the basic guideline on the ground of fraud,
Clause 2.8 of the 1979 regulation, page 16 of the learned single judge order. It is quoted in the learned single judge order.
I be permitted to keep.
It is quoted. There is no dispute that it is wrongly quoted. We can rely on this.
so my lord, so which I was going on about this agreement part. May I conclude that? I will reply.
Yes, yes. You may proceed in your way, whatever you want.
Regulations action on the inquiry report.
Yes. That is 7.7.
Regulation 7. I will place 1, 2.
That is also quoted in the single
Yes,
judge order. 7.2 is at page 14 of the single judge order. Yes.
Yeah, I did for you.
Yes.
Sir, I had a copy.
Huh? Take a copy.
একটা copy.
আমি কোথায় বলবো?
This is almost a service regulation. This is the vital thing. 7.2.
That is one aspect. That is one aspect. That reason, the rule requires.
Yeah, please 7.
Yes.
7. The disciplinary authority, if it is not itself the inquiring authority, may, for reasons to be recorded by it, remit the case to the inquiring authority for fresh or further inquiry and report, and the inquiring authority shall thereupon proceed to hold the further inquiry according to the provisions of the Rule 6. If it is disagreement, can remit back, remand. 2. The disciplinary authority shall, if it disagrees with the findings of the inquiring authority on any articles of charges, records his reason for disagreement and records his own finding on such charges if the evidence or record is sufficient for the purpose. I want to segregate that. Under Order 41, my lord, your lordship knows, if the evidence are already on record and he is able to scan the evidence, reappreciate the evidence, this power is given. He can give his own finding. This disagreement note is only there if there is no evidence, he cannot decide out of his own. He can say, no, for this reason it is not.
Yes.
If your lordship look to this own finding before the appellate authority,
Not appellate, disciplinary authority.
here my lord, why I am saying there is upper authority. The disagreement means by the higher authority has confirmed the punishment or not.
No, inquiry officer does not suggest a punishment.
No. He will send it.
He will
He
only give,
disagreed.
he will only give his findings based on the material, whether it is
Proof or not proof.
proof. That's all.
Nothing more than that. Now, if the authority who is imposed punishment, he finds that the introductory report is not sufficient, he can remand it. If he thinks that materials available before the disciplinary authority which was sent along with the introductory report, the evidence are gallored to come to his own finding. And if he finds that on the scrutiny of the evidence, by its own finding, the disagreement note may not be necessary. What will say? I'm asking the question. This is the evidence. I find that this charge is proved. If it is higher authority, appellate authority, the higher appellate authority will scrutinize whether the actual evidence which was there had been scanned properly, appreciated properly, and come to a finding. Whether there is any specific finding, and kindly keep in lordship's mind, he is not a judicial authority. He cannot write a judgment like my lord, a court. Now my lord has to see whether when your lordship will be going to the disagreement note along with the evidence scanning and come to his own finding whether its two is complied. On the plain reading of that, my lord, your lordship will be satisfied that the two has been complied with in its terms.
May I take short leave of it?
Excellent. Well, another matter is prefixed. I am your my lord's hand.
Both are required. Agreement and finding based on material. You don't want to continue today?
Saying, well, tomorrow, I have no problem. I understand, but the process is stalled.
Yes, we are almost more than halfway through your submission. We can continue tomorrow. As matters. Yes, opposition to the application kept on record.
Let's start from there. Please activate.
Parent 12.
The respondents make the law.
Start पे आपसे पढ़
By opportunity. হ্যাঁ আপনাদেরই বলা ছিল Paper book has been filed.
My lord. My lord, you find the impugned order at page 198.
page volume 2. On the last occasion, 198. Yes, yes. That is the description exercise. Yes. Correct. Yeah. Help. Okay. Without intention, but specific time.
Three findings, three issues considered. First issue of an alternative remedy. So the court took a view that these are self-imposed restrictions. That apart, the court considered that now he's in a supervisory grade. That issue, that objection of the bank was not sustained. Second was delay. Delay also, the single judge did not entertain because he said you were pursuing a remedy for availing gratuity. After payment of gratuity, the funds are available, you have moved the court. Last is the finding on merit. The inquiry officer says, yes, this mistake was committed, but in a routine way, there is nothing on record to show that it was accompanied with ill motive. So in absence of ill motive, these three findings have weighed in the mind of the court to grant the relief to the writ petitioner. So how these three findings are not sustainable, tell us. First is regarding the alternative remedy. Second is delay. And third is the finding of the inquiry officer. Based on such findings, without a disagreement note, how a charge can be held to be proved? Unless there is a fourth point which you have. We are not limiting what we could gather, we have only said.
The fourth point is, so for the alternative remedy delay and Malatas. Third point is the petitioner has never said that he is not guilty. Rather, he says the punishment is disproportionate one.
That is his only ground. He has not submitted a written statement of defense denying the charges.
Yes, kindly see the yes stated in.
What is that page 18?
Paragraph page 20
of
the paper book.
No, sir. We are asking you after a charge memo was served, he has submitted a written statement of defense.
Yes.
So he has admitted to the charges.
Yes, stated that charge sheeted so for the reply.
He must have denied the charges, then only a proceeding would commence. Normally, that is the procedure specified in most of the rules.
Shifted the burden upon the another person, Torun Kumar Banerjee, who is also the co-accused in the matter, my lord.
So in the writ petition, you are saying he is confined to quantum of punishment. Where you are saying that?
Well, he has stated in the writ petition.
Your lordships are asking whether in reply to the charge memo, what is my response? That whether it demonstrates that there is an element of admission for which we
No, let him complete. We'll come to you. Yes.
But, page 20, in the writ petition, paragraph 10. However, although evidence and deposition on record do not suggest any malified intention on the part of the charge-sheeted employee, and the mistake show in all likeliness is unintentional, there is no denying the fact the transaction was verified by Sindonath Mukherjee in a routine manner. In first, he has submitted, he has verified the same. And second, another 20.
So what are you trying to submit based on these pleadings according to
page 25, my lord, paragraph 14.
Yes.
Page 25, paragraph 14. Your petitioner states that on 22nd October 2013, the petitioner herein preferred an appeal before the appellate authority, being the respondent number 2 herein, on the ground of punishment being disproportionate to the charges proved against the petitioner. Therein, the petitioner narrated his defense as mentioned in paragraph 9 herein above. Further stated, the fraud that was devised by the said Taposh Banerjee and 4 other officials was investigated into by the police and CBI authorities. After interrogation, the said Taposh Kumar Banerjee and 4 officials, they were arrested and suspended from service. The police in their investigation never found the petitioner being involved in the same. He further brought to the notice of the appellate authority that 4 officers who were suspended were reinstated and posted to the different branches, excepting Taposh Banerjee, who it turned out intricately connected with the fraud. Whereas while the petitioner was not found to have anything to do with the said fraud, and in the fact he was a victim of the malicious scheme of the said Taposh Banerjee, a disproportionate punishment was imposed upon the petitioner. He never stated, my lord, that I am not guilty. He stated that punishment is disproportionate one.
No, we don't. Anyway, so that is your submission based on paragraph 14.
Paragraph 14 and yes.
He has sought a specific relief of setting aside of the charge memo. He says inquiry report is not sustainable. He says disciplinary authorities order is not sustainable. That is a specific relief.
And so far the charge sheet is concerned, there as per the clause 5J of the memorandum of settlement on the disciplinary action procedure for workmen, there clause 5J says doing any act prejudicial to the interest of bank or gross negligence or negligence involving or likely to involve the bank in serious loss.
5J.
5J of the memorandum of settlement.
Is it in the paper book?
No, paper book এর মধ্যে part of the paper book কি?
If it is not in the paper book, please give us a copy.
Yes, sir. আরো কপি আর একটা কপি লাগবে, এই তো দুটো কপি। দুটো জজ সাহেবদের জন্য দুটো আর একটা কপি বের করে মেলে ফাইভ পেয়েছে কারণ ওকে দেখা নেই
5J.
By expression by gross misconduct shall be meant any of the following acts and omission on the part of the employee. 5J says doing any act of gross negligence or negligence involving or likely to involve the bank in serious loss. Here, my lord, likely to involve the bank in serious loss.
So according to you, the rule does not contemplate a concept of intention or mens rea.
Yes.
The moment it is a negligence which is likely to cause a loss to the bank,
yes, likely
becomes
to cause,
it constitutes a misconduct.
Yes. Documented.
How you can rely on the amended provision? You have to go by the earlier provision. Charge memo is of prior to 2020.
Well, it is settlement dated 10th April 2002.
What is the date of the charge memo?
Charge memo is 13. It's 60.
May 60.
29/8/13.
13. Then it is covered by.
No, sir. Please read page 1 of this document that you have given us at the top, above the table. Next page above the table.
The details amendment.
Now 5J is in the first box. No, at that page only. 5J after 11/11/20.
J, doing any act prejudicial to the interest of the bank or gross negligence.
Correct. So that is the definition which will apply in 2013, not the subsequent one.
Subsequent is doing any act of gross negligence.
But that is amendment of November 2020.
20. But existing was
Doing any act prejudicial to the interest of the bank,
Yes.
perhaps.
yes, that was prior to 2000.
November 2020.
2020 only.
That is a provision in vogue at the time of issuance of the charge memo.
Yes. The deletion was partial deletion of existing gross misconduct.
Whatever it is, but we have to go by this. Maybe inconsequential, but there is an amendment.
On the basis of the same,
so whether we look at it in the amended or pre-amended, the situation remains the same. That motive is not required to be established. The moment there is a likelihood of loss, it will constitute a misconduct.
Paramount consideration before your lordship. And so far, my lord,
and negligence is defined in the rule.
There is no definition of.
Because the rule lays emphasis on two terms, negligence and gross negligence, as if they are two terms specifically defined.
Here there is no.
Is it defined? No.
Not defined.
So who will decide whether it is a negligence simpliciter or a gross negligence? Anyway.
And mere negligence is not a misconduct, my lord. It has to be a.
No, it says negligence or gross negligence, both. Therefore, we are wondering whether there is whether it is, amount based or something, that if it causes a loss of more than such and such amount, it will be deemed a gross misconduct. Prior to or anything below that will be mere negligence, above that gross negligence, but there is no such thing.
Then we have to take the cue from the dictionary meaning what is negligence. That means, my lord, the standard which required to be followed, that has not been followed. So for the negligence is concerned, whether it is a judgment in error or intentional error, even if we assume that it is not intentional error, but he has not followed the proper standard at the time of verification of the same ballot. So far that your lordship knows very well that so far the banking institution is concerned, integrity and honesty should be maintained in the highest rate as well.
Yes. And enforcement of those standards by the higher authorities is also required to be with the same amount of diligence. Yes.
Well, so far the whenever the punishing authority is the disciplinary authority, the scope for review before the court is very limited, unless and until it can be shown
that the natural justice has been violated. He never stated that at the time of inquiry, he was not allowed to argue or he was not allowed to cross-examine somebody. That has been taken. Therefore, the disciplinary proceeding has been done following the natural justice and fairness.
So is there a finding recorded by the inquiry officer that actually that introduction document was replaced?
Allah kindly come to.
Because one Mr. Tapas, something has
Yes, he was
introduced that was countersigned. It says subsequently it was replaced and introduction by some organization was inserted. Is there any finding by the inquiry officer that yes, that document was replaced based on such and such evidence recording? Is there any such finding? Or it is merely endorsement of the introduction? What is the finding? Whether it is gross or mere negligence?
on page 96.
Yes.
Already in terms of letter number such and such of the disciplinary authority, the zonal manager Kolkata zone, I was appointed as the inquiry officer to inquire into the charges level against Sri Indranath Mukherjee, employee number such and such, special assistant UCO Bank, Westing Branch, Kolkata, filed charge sheet dated 29th August 2013. Sri Anjan Kumar Ghosh, manager zonal office Kolkata, was appointed as the presenting officer by Sergeant. The first hearing in respect of the said charge was held on 12 September 2013 and thereafter second hearing was held on 16 September 2013. The hearing was concluded on 16 September 2013 itself.
See, the findings are at page 97.
97.
EO's assessments.
Yes, it is evident from the documents submitted by the presenting officer during inquiry as well as deposition made by the presenting officer and charge sheeted employee in this regard that Sri Indranath Mukherjee verified the modification of introducer name using his ID in the system in the number such and such shared by entered by Sri Taposh Banerjee on 9 January 2013. Mr. Mukherjee stated in his defense that he has verified the above data in good faith. Mr. Taposh Banerjee, to whom everybody in the branch was, and he was no exception. Branch was dependent. From the above, I am of the view Sri Mukherjee should have taken with more caution at the time of verifying the above data, which he did not and verified that. However, although the evidences and deposition on record do not suggest any malintention on the part of charge sheeted employee, the mistakes so committed in all likely unintentional, there is no denying the fact that the transaction was verified Mukherjee in a routine manner. As such, I am inclined to treat allegation as proved. In view of what has been stated above, I am inclined to state the charge level is proved as under doing any act prejudicial to the interest of bank.
So there is no finding that the account opening form was replaced. There is no finding of that. So whether it will be considered as a gross negligence or negligence simpliciter.
But following the clause 5J of the settlement, they have come to the
that is the submission on the findings. Anything else?
So far, the scope of the court to interfere with the disciplinary proceeding, Your Lordship knows, I am relying upon Supreme Court judgment, that is Central Industrial Security Force versus Akbar Ali.
The proposition.
Proposition is when court can interfere with the
limits of judicial review.
Yes.
Decision making not process, not the decision itself.
Yes.
When there is some material, the court should not interfere. Only in the case of no material, court should interfere. Anything else?
No, that is a And I also relying upon another Supreme Court case on the same point, my lord, Balaram Bordoloi versus Lokhi Gwalia Bank.
What is the judgment of which year?
My lord, it is 2010.
All these judgments, subsequently, Guna Sekran case, why don't you come with that case? If the entire do's and don'ts of a court have been summarized in 2 paragraphs.
P. Gunasekaran.
Yes. Yeah, I am getting much more insight into things.
Kindly do not lend your lordship's ears to his lordship.
Yes.
In it.
By that. If I summarizes the entire thing, I will just show you the 2 paragraphs wherein it says what is to be done and what is not to be done.
But in read, এখানে বসে বসে ডিস্টিংগুইশ করতে হবে, এখানে বসে বসে করতে হবে, পরীক্ষা হলে কোশ্চেন আসছে, এখানে বসেই করতে হবে। Do it now.
Paragraph 12.
Yes, yes. Despite the well settled position, it is plainly disturbing to note the High Court has acted as an appellate authority in the.
12 says what we can do and 13 says what we cannot do.
Yes, yes.
It comments to you, will proceed.
Inquiry is held by a competent authority. Inquiry is held according to the procedure prescribed in behalf. There is violation of principle of natural justice in conducting the proceedings. The authorities have disabled themselves from reaching a fair conclusion by consideration extraneous to the evidence and merits of the case. The authorities have allowed themselves to be influenced by the irrelevant or extraneous consideration.
Relying on para 13 and he will be relying on para 12.
And the conclusion of the very face of it, so wholly arbitrary and capricious that no reasonable person could ever have arrived at such conclusion, and the disciplinary authority has erroneously failed to admit the admissible and material evidence, and disciplinary authority has erroneously admitted inadmissible evidence which influence the finding. The finding of fact is based on no evidence. And 13 is, my lord, High Court shall not reappreciate the evidence, interfere with the conclusion in the inquiry in the case the same has been conducted in accordance with law, going to the adequacy of the evidence, going to the reliability of the evidence, interfere if there be some legal evidence on which findings can be based, correct and the error of fact, however grave it may appear to be, and going to the proportionality of punishment unless it shocks its conscience.
Still within the age of superannuation.
Yes, you already crossed the age of.
1 week after charge sheet.
Oh, yes, 1 month after.
For 1 month. Not 1 month.
So the charge sheet was issued 7
29th August 2030.
memo was issued 7 months after the occurrence and 1 month prior to his retirement. That the judge.
Photographic memory.
No, no. We read so many times that it becomes. Any other issue?
All these are more or less.
Yes. Milord, the invocation of
On 5J, please make submissions on 5J.
5J, Milord, is Milord a complete misunderstanding, Milord, and it cannot be applicable for the simple reason because Milord, the post, the service which are rendered in post, Milord, that is absolutely managerial. Number 1. The 5J, Milord, this particular regulation, Milord, does not speak about Milord the role. Milord, special assisted Milord, to which I was attached Milord prior to my retirement. Prior to the Milord, the punishment order.
You have a better copy of page 97. Anybody?
97.
The last words in that whole page are not printed on the extreme right side. From top to bottom. Although we can very well make out what it was going to say, but it is not there. On the right side. Because this is the finding which will be the basis for everything. Yes. So every word is relevant, therefore we are asking.
Can you produce this? The original?
However, just see, however, although evidences and depositions on record do not suggest any M,
Yes, my lord.
malintention, what is it trying to say, material,
Yes. একটুখানি এইটার একটু আসুন আপনি আসুন
you have a read record, see from the read record.
কেন বলছি শিখবেন
That may be relevant, therefore we are
yes absolutely my lord এইটার অরিজিনাল কপিটা বাড়িতে আছে ইনকোয়ারি রিপোর্ট ইন রেসপেক্ট অফ দ্য চার্জশিটের ইনকোয়ারি রিপোর্টটা এই জায়গাটায় 97টা But is there a question of better?
No, it is a better copy. This is the original copy. Not the original. This was part of the retouch, but it's marked.
Yes, my lord. But I can get it typed minute by today, my lord.
We'll continue tomorrow then. For further submissions, the matter is adjourned. Bring it, just ask them to give a typed copy. Ask them to be email or something, it can be sent.
Send it to email.
Tomorrow with not today. Get a copy, legible copy, exchange it so that we can proceed.
Yes, tomorrow.
Tomorrow with not today. It will be taken up day after.
Yeah.
The day after tomorrow, can
It marks Monday.
21st minute school service matters.
Monday? Monday. Monday at fixed time.
Monday at 2 p.m. possible, 3 p.m. 25th, your lordship.
We have heard almost everything. We'll fix it at Monday at 12:30.
Well.
Conclude within 15-20 minutes. What is? Please conclude it that day. Yes.
Madam 13.
Last of
There is a direction unauthorized debit transaction.
Where is he?
Without.
He was here.
Was here.
That's why we asked you. We saw him. He was just sitting.
On the last occasion, my lord, asking for the documents. Last order, my lord, on appeal. This is the forms. Giving both copies. At the time of pension, my lord, they had undertaking this and the pension forms, my lord. When the excess money is paid, my lord, it is.
My lord, kindly see the undertaking. Every month by credit.
একটু বাঁধে করবেন
It is letter of undertaking. No stamp paper, nothing. Anyway,
It is the form, it is the entire pension form.
my lord,
You will see that you can do it. So this is without a proceeding.
without
Recovery is without a proceeding.
no proceeding,
No departmental proceeding.
This
nothing.
is not the departmental, my lord. It's the commutation proceeding, my lord. Excess payment made at the time of commutation calculation.
My lord,
When the pension has been paid, my lord, excess money has been paid in his account. My lord, kindly look into this page number 43 and 44.
So who decides that this is an excess payment?
Well, this is excess payment, my lord, calculation by the bank. It is given to him.
no, nothing. My lord, kindly say,
Please.
Entire
please
order,
sit down.
entire order, my lord. In the entire order, it is, my lord.
Now see, we have raised a specific issue.
Yes, my lord.
Whether a recovery can be done by the bank in this way. You are relying upon some
Form 9. Yes, my lord. Form 9.
The form 9 says which amount is to be recoverable, which he is not entitled to.
Yes, my lord.
Who will decide that he is not entitled to? And where a decision will be taken that he is not entitled to?
When the
By the bank itself.
When the calculation is made, my lord, it is nothing excess. When the pension scheme coming, excess pension payment is made, well, I for you to one page, just
Who
one
made
page.
the excess payment?
Bank made, my lord.
Who authorized that excess payment?
Well, kindly the calculation is
Which officer authorized that excess payment? You have proceeded against him.
not excess, my lord. At the time of commutation, my lord, it is excess payment on the same day, my lord.
Who did it? You have proceeded against him.
My lord, the same day, my lord, same day excess payment. My lord, it is the calculation by the bank because there is no pension scheme. And when the commutation, the area, it is area, my lord. Where the
I
area
am
is
not asking what is the excess payment.
So kindly look into this.
We will not. We are only on procedure. We are only on procedure. We may come to a conclusion that yes, he is not entitled to this amount. Can it be done in this way? That is all. We are not saying that he was rightly given the amount.
My lord, when the pension is, my lord, when the pension scheme is coming, my lord, excess, when the commutation is giving, my lord, the area pension is giving, then this excess payment is giving to the petitioner, so it is recovered.
no notice.
My lord,
nothing
this is the chart, my lord.
No, we are not going to sit over in appeal over your calculation. Was he given opportunity that look this calculation?
It is his undertaking at the time of giving pension.
So only on this you are relying. There is no opportunity given. That is an admitted position.
My lord, more than 1,000.
We are only on facts.
Yes, my lord, this is the fact. On the form 9, my lord, we are every pensionaries who are applying the pension for the scheme.
And what is the excess amount according to you?
My lord, it is 1,27,870. He paid, my lord,
1,27,000.
870.
Already recovered.
Yes, on that same, my lord, kindly look in the page 43. Page 43 of the petition, my lord. Within 5 minutes, my lord, it is excess payment and same day it is recovered. Page 43, 44 of the
Same day.
petition. Same within on the 20th 11 2020 2020 it is 20th 11 2020. Well, page 44.
49.
We'll see. We are coming back. We'll see.
I'm for the respondent number one.
For the appellants. So it's fixed today. My learned friend would be completing their submissions.
The other way.
That's what we are just thinking. It was heard by the other bench of the other composition.
But we'll also have to wait for it perhaps because my lord perhaps my lords otherwise would not be able to take this up.
Oh.
Justice Roy,
Otherwise also.
otherwise.
Oh. What we'll do is, see, we don't know how long this bench will continue.
My lord, till some certainty, my lord.
I will adjourn it for 2 weeks.
Yes.
If not, then
Then my lord, we'll figure out, my lord, what is to be done.
because otherwise it can't be considered by this bench. We are informed. Even did.
In September. Great portrait.
I have to wrap up.
Instead of 2, we are making it 3 weeks,
Yes.
as suggested by the court after looking at the.
Item number 86.
I must say the same, my lord. It's that matter, my lord, where the wideness of the rule has been challenged and the women have been completely outstepped. Your lordship heard, which my lord Justice Procedural বিশ্বাস, my lord. I have concluded my part of the hearing. My lord, they have to produce one order, my lord, with regard to the OBC part, whether
there is, you have any instructions?
I have no instruction, my lord.
May I say, my lord, I have gone through one order where, my lord, the authorities approached the learned Advocate General. The Advocate General opined that if a selection process is constituted prior to the judgment, that will continue the same fashion. There may not be any departure. But those selection process took place after the judgment of this honorable court, my lord. In their cases, my lord, that can be consideration. In my case, I may not say is there.
So it may not be relevant here.
Absolutely, my lord.
Same order as the last.
Sleep, sleep.
Item number 87.
May it please your lordship, my lord, we are appearing for the, my lord, the respondent petitioner, my lord.
I'm appearing for the petitioner, my lord, led by Mr. Dheeraj Kumar Trivedi, learned ASG, my lord. We have already completed our submission, my lord.
So kindly take the previous orders starting from 6th of May 2026. My lord, the prayer has spread the list of matters such and such of 12th of May. Then, my lord, the preliminary objection has been raised, which has been recorded. Your lordship was pleased to record the same. The order dated 12th of May 2026. Affidavit of service filed on behalf of the appellant is taken on record. Learned advocate for the writ petitioner respondent raises an objection regarding the bona fide of the appeal and submits that the appeal suffers from
Here also considered by the other bench earlier.
Milord, not a part harm mentioning only. No substantial decision was taken. Simpliciter, Milord, condonation of delay application has been allowed. I don't have any objection. I am leaving the matter to your lordship, Milord. It is up to your lordship to take a decision.
Well, it will, my lord's pleasure to hear it once again, lordship.
That's precisely what we were pointing out, because his submission was not made before his lordship.
Lordship, on the last occasion, my lord.
You are yet to make your submission. So you can make it, but then he has made his submission.
But the Milord, principally or substantially, the matter has not been heard. My learned senior friend has advanced his argument. Only the application for condonation of
As
delay.
far as we know, the law, the court's order sheet is sacrosanct. The last order in detail records his submissions.
My lord, I am
Since
leaving
we have not said part heard, therefore it will be treated as not considered.
I am leaving the matter to
If
your
you are
lordship.
trying to make that submission, then that will be opposed to the record of the court.
I will not say. I will not say.
So therefore, we ask Mr. Trivedi, and he's correct in taking a stand. Therefore, what we are doing is, see, after we don't know how long this will continue. So in whatever matters are coming up, we are adjourning for today. In the meantime, that earlier composition is restored well and good. If not, then we may have to fix it, or we can fix it with that bench on a particular.
Milord, whatever falls from your lordships, Milord, I am ready and willing to, Milord, because, Milord, for me, Milord.
So see, whatever you submitted is recorded.
Yes, Milord.
So we can take it up after 2 weeks. If this bench continues, then you may refresh and we'll proceed. If the bench does not continue, if we are resumed with that bench, then they will make this.
Great.
Item number 18.
Yes, Milord.
In 88, I am for the appellant.
আমিও applicant.
আমি বলি, in 89, my learned friend is for the appellant. But in fact, the writ application has been allowed, granting the pension, freedom fighter pension, with effect from the date of the order. So I have challenged that order.
Same order, sir.
Same order, sir. Same order.
যে অর্ডারটা চ্যালেঞ্জ হয়েছে
পুরোনো বেঞ্চটা আবার রিকনস্টিটিউট হয়ে যাচ্ছে তাহলে উনি শুনবেন, না হলে তো ফ্রেশ শোনাতে হবে আপনাকে।
As your lordship, I could not follow.
Let us give one opportunity that bench.
As your lordship.
We remember that certification by an enlisted person.
My lord, that is, and our contention is, lordship, no, my lord, I will not waste, I will not. My lord, that is my exuberance, my lord. I still want to address my lord at least for 30 seconds.
But we have to.
But in fact, I am lucky enough that I have got my adversary like Mr. ASG, Mr. Trivedi.
He has given me a lot of blessings, my lord, right from 2018-19. My
Item number 90. 90, my lord, I appear for the appellant. This matter was heard by your lordships. I am for the petitioner.
These matters will be on 9th.
On 9th, my lord. 9th September.
Same order.
Granted, man.
Lordship, I am what happened. Respondent was he was arguing. Unauthorized debit transaction.
I should not disturb your lordship, my lord. The last matter, item number 90, your lordship was pleased to direct that matter to come up on 9th, my lord. Probably of the view that the matter was heard by another bench. It's not that this bench, this honorable bench heard that matter. This 90, item number 90, the hearing was concluded, my lord. So it's on 9th, my lord. We will come back on 9th, my lord. It was only for judgment that matter was kept. Justice Roy and your lordship heard this matter. This is that matter, my lord. There's only the age dispute, my lord. I was compassionate appointment. I was saying that let this writ petitioner be, my lord, sent to this ends. This was only that matter, my lord. It's a very short issue, my lord.
You did.
I'm sorry, my lord. We should have pointed out, my lord, when the order was passed.
Both sides are here.
Yes, yes, my lord.
And for the not today.
Let it, my lord. Let the order be there. Let it come on 9th because your lordship is to pass the judgment.
Not heard by a bench of another.
Yes, very well. Very well, my lord.
Not today. Not today.
Not today, my lord. Very well. Very well.
Order 9. Sir, order 9. Chapter 5.
কোথায় চলে গেছে?
70.
Okay.
If you were showing the order by which the credit and debit was made.
No, not order, my lord. It is a mere calculation. Let me finish. It's a calculation.
Said on the same day it was deposited and withdrawn.
Yes, yes,
Where
it
you are saying that.
My lord.
Page 49.
Page 49 of the, my lord.
Page
Stay
40,
application.
stay up.
My lord, it is a calculation of the area of the commutation value of the pension, my lord. And the excess payment has been made in the
On the same
calculation.
day.
Both, my lord, page 49.
Yes, 49 is the calculation.
No, my lord. Page 49 is the amount paid 7,12,000.
First disbursement, second disbursement.
Yes, yes, that.
On which date this payment was made?
20th November 2019.
Where do we get the date?
Left side, my lord, date.
Nothing has been disclosed here.
Where is the date?
Left side, my lord, extreme left.
Date.
No, that is the areas. Page 49.
Yes, yes. 49 of the stay application.
Oh.
Commutation and recovery commutation.
And where you have communicated to him why you have made this recovery?
But the excess payment, it is, there are several letters, my lord. He is annexed in the writ petition, in his mail, and reply is there, my lord.
Where you have communicated to him
Yes,
the basis for the recovery. Where is that communication?
my.
Don't say various letters, various information.
He is annexing all letters.
What do you mean various? What about that?
আচ্ছা, রাহুল। From যেমন আছে কি? আচ্ছা। তো next করেন কি? One second. Supply of the pension commuted value. On page 36 of his supplementary evidence. The petitioner is make complaint before the UCO Bank regarding his deduction and the
And then
reply
you say this
after,
point.
after when page 38 the reply where the deduction, where is the order, entire reply, my lord, page 38.
So no intimation either prior or after the recovery. Only when he
Already, my lord, there is a when the this is, my lord, not disciplinary, nothing any any, my lord, disciplinary proceeding, nothing. It is a miscalculation of the, my lord, commutation value of the pension.
precisely that is what we are asking you.
Yes.
Did you say before the recovery that we are recovering due to a miscalculation, or did you say after the recovery that we are recovering due to a miscalculation?
When the form
You
was
want to speak over us? Please keep you keep continuing. Yes, you speak over us.
Tendering apology.
No, no. This is a very good way of arguing. You speak over the court. Please do it.
I'm tendering apology. I bow down before Lordship.
And that will really help your client.
No, I'm bow down before Lordship.
Yes. By speaking over the court, you will get orders
No, ma'am.
which are favorable to your client.
Ma'am, I'm bound
But
on,
please don't have such a misconception, anyone.
ma'am, I'm bound on before Lordship, my lord, on the part of my. Yes, I'm tendering apology.
So admitted position is neither prior to recovery nor after recovery, you intimated or considered it fit to intimate that look, there was an error in calculation, we have recovered it. How this error has occurred, what is the amount of excess payment, where is that basis? Where is that? Show us from any reply that you have sent. How you have arrived at a figure X that this is excess payment.
My lord, page 36, my lord,
Yes,
when the
of the supplementary.
of the supplement.
Yes.
My lord, this is the complaint regarding unauthorized deduction petitioner made before the concerned bank. And my lord, the reply 38 is 38. 38 or 43. কোনটা আপনাদের পেজ কোনটা মানে 43 মানে this is the reply.
This is also put to challenge in the writ proceeding.
Yes.
You have challenged this also.
But in the
You have challenged this order.
yes. The supplementary list ছিল.
So what is wrong with this order? Tell us.
I was not in the writ petition. That is my whole difficulty. Writ petition এটা দেওয়া হয়েছে।
Sorry, please come prepared.
Let it be on Monday.
As paid by the list up next Monday week.
Next month. My lord, deeply. নামটা দিয়ে দাও নামটা now 31st August.
Sir, it's my fault, my lord. I'm my lord. I can follow your law.
Your enthusiasm is appreciated
My lord.
in so far as it is within.
My lord. I'm very.
Item 14.
In your lordship, we beg to appear on behalf of the state. Yes.
Yes.
My lord, I plead matter appears total alarm.
Huh? Not today.
Not
Not this week.
Piyush Mondal, not Kaushal Alam. Petitioner's name is Piyush Mandal. Petitioner is Piyush Mandal. So item number 14.
He is probably saying the name of the learned advocate.
Acha, acha, acha.
There is a delay, application for delay also.
Yes, 6 days delay. From the averment, it is a 6 days delay only.
First one. Yes, what is your stand?
Well, the appeal is does not have any merit, your lordship. So far, section 5 is concerned, well, a necessary order might be passed. 6 days delay only. But so far, appeal is concerned, my lord, it does not have any merit. Because, my lord, they are belong to exempted category. Okay. As a director of employment, we gave him sufficient opportunity. 4 opportunities are there. We have the report. And they have to qualify. They have to qualify means they participated in the written examination, in oral interview, they failed. They have to, selection as per merit. That is our stand.
Read paragraph 6 of the order of the learned single judge.
I do not have anything contrary to the paragraph 6 because on earlier occasion in the similar circumstances, the earlier state advocate argued that opportunity we will give him. We gave him opportunity, and if situation and circumstances demands relating to his seniority, age, qualification, caste, etc., definitely we will give. But he has to participate. And the finality based on merit. That is our stand. It does not mean that automatically as a land loser exempted category, he will get his employment automatically. That is not our stand. Our stand, exempted category persons, we will inform them, they participate, and from the exempted category, the best person will get the employment. That is our stand.
Where is the order passed in the case of Pradeep Kumar Bandal?
Well, it is not annexed with this writ petition. Even in the from the server, I saw that, and there it is Honorable Justice Bivas Patnaik passed this order. I read the order. Yes, in the official website of our Honorable Court.
No, he is claiming parity with that person. He must have referred to that. Yes. Tomorrow?
1 week.
Why, madam?
Due to illness, my illness, my lord.
Illness. An application for
Most
And you are putting.
obliged, your lordship.
Item 15.
My lord, in item number 15, my lord, and for the writ petitioner appellant, my lord, in MAC number 2038 of 2025, my lord, led by Mr. Owen Banerjee, my lord.
and MAT 54 is filed by the respondent.
If your lordship takes up my appeal, but of course, my learned friend's appeal has all the papers. I would say that, but if your lordship takes up my appeal from his papers, it will be better for your lordship because my case is against the entire, because if I succeed, then the question of my learned friend's appeal would not arise. And
Let us see the order.
if I fail, then will not the question of my learned friend's appeal.
Let's see the order.
My lord, in their appeal, my lord, there is one section 5 application that
Yes,
is.
there is also section 5. I don't know.
How many days?
My lord, they have mentioned it as 196 days, my lord, but it will be little lesser, my lord.
Let's see.
41 days.
41 days. No, 64 days.
They have wrongly calculated, my lord. Days.
Why do so many matters we come across? The application it's filed without checking the stamp report.
But just out of curiosity, has the stamp reporter said that there's no delay?
No, it says 64.
Oh, that's half. No, not even a 1/3.
64.
You have said 41 only.
No, I have said much more.
They have said 196, my lord. Days. Perhaps my lord is looking my appeal.
Other.
My lord is looking at my appeal 2038. That is my appeal, my lord.
There is 41 days.
There was. Which has been allowed now.
My lord, that our delay was condoned, my lord.
My learned friend's application.
Your application number is 2 or 1.
Their condonation delay is 1, my lord.
Very well, that we are allowing. What is let's see the merits.
My lord. I leave it up to your lordship, my lord, considering
the application. Single judge has interfered with yours.
Single judge interfered, restored his service, but because he had retired in the meantime, but refused back wages. So his appeal is for the back wages. My appeal is against agreed by this. So this is the basic, the sum and substance of the.
So substantial relief is claimed by you.
But yeah, that is why, my lord, I said that if your lordship takes up mine, then
So
possibly-
what infirmities were found which according to you are not sustainable?
my lord, I'll tell you, lordship.
Just briefly. Before
Yeah,
we
very
go-
briefly,
yeah.
without going in the papers, but I'll take your lordship. Basically, as far as the procedural part, everything the learned judge held was correctly complied with, everything. But because of the fact that there was a criminal case where there was a acquittal, says the learned judge goes by that line of judgments which say that if on similar facts, similar basis, similar principles, similar
Same set of allegations, same set of evidence.
yes,
Yes.
then in that
Benefit
case,
is to be given in the departmental proceeding.
yes, then effect, and not only that, but the learned judge did not take into consideration that that judgment has not reached finality and there's an appeal pending. This is when, if you're not one, this is the crux of the story.
So he has not found any procedural in.
He says that everything is complied with and says that there's no ground for him to be agreed by. All that is concerned. Which the your lordship knows the series of judgments that are there. My lord, I am not. Your lordship knows it better than me. Which says that your lordships are basically an umpire to see that everything is complied with. But on that score, the learned judge has held everything in my favor. But because of this criminal court says that no. There again, my lord, I will say that the judgments of the Supreme Court, which the learned judge relied upon, will not specifically say that everything has to be similar, identical.
Paul Anthony and GM.
Paul Anthony and GM. Yes, grateful, my lord. As I said, I don't want to.
All those judgments have.
All the judgments which are there, that absolutely. But they say they have to be identical.
No, there is a more recent judgment. That's why we asked you, where the apex court said complete oneness.
That is what I am aggrieved by. I'm telling you, lordship, this is the crux of my case.
You have that subsequent judgment.
My lord, this is
more recent judgment.
My lord, Pradeep Banerjee versus Union of.
If only we remembered, we would have told you.
I'll look it up, my lord.
We have seen it recently, therefore we are saying.
My lord, we will
The
try to
concept,
find it
because
out.
the apex court said there is no such concept of an honorable acquittal not defined in CRPC, IPC. There's so insistence on these things. Perhaps judgment authored by His Lordship Justice Chanchud, where he says that issue of complete oneness between the allegations and material considered in both the proceeding. If there is a complete oneness, then perhaps then the issue will come whether when they say it has not attained finality, so should they wait till the appeal is disposed of?
My lord, during pendency of hearing of the writ application, my lord, there was no appeal, my lord. They could not supply, my lord, the even number.
No, let's take it that there is an appeal.
No, there is. I have got the papers.
It may be filed late, whatever.
My lord.
What will be the effect? That we have to see.
There is delay, my lord.
Whether
Delay has not been
benefit of the findings that criminal trial can be extended. If there is a situation that yes, it can be extended, then the fact of filing of an appeal, will it in any way come in the way of grant of such relief?
Yes, my lord. This appeal may take, my lord, a
Yes,
long
that's why
time.
we are wondering. It's a
And my
criminal
lord, the writ petitioner, my lord, dismissed in the year 2007, my lord. His superannuation in the year 2015, my lord. My lord, all these years, my lord, he has been deprived from his.
No, I don't think as somebody who's been a trap case was laid down for him, he was caught red-handed with the money.
My lord,
I-
even the
one thing we want to be the claim for back
Yes, my
wages.
lord. Yes, my lord.
That is it.
That is
That your lordship can take it from me.
back wages, and
We'll have to consider, sir.
my lord, one aspect is there, my lord. Our prayer is
The law is very well settled that when you get the benefit of a criminal trial, the employer cannot be saddled with such a liability because it was not due to a fault on the part of the employer. Once you have been acquitted, you are getting the benefit.
My lord, my case is not only that, my lord. We are
No,
glad-
that's what we asked you. if you're only claiming back wages, then the court is a consequence of finding by the criminal trial. You can get a back wages. That is
My lord, the finding of the learned trial judge, my lord, we have also assailed that, my lord. My lord, in some respect, my lord, where, my lord, some aspect, my lord, we have argued, my lord, that has not been considered, my lord. Although repetition has been, my lord.
Just now we asked you, you said yes.
My lord, that is our prayer, my lord. That is our prayer, my lord.
Senior to assist your lordship, Mr. Banerjee is his senior. He's not here. I don't want to steal any marches, my lord. Your lordship will take it another day. I don't have a problem with that. Let
My lord,
Mr.
in that-
Banerjee come. Then whatever happens, my lord, it's my also duty as a my lord.
My lord,
It's a junior only. I don't want to steal any march.
because, my lord, the retiral benefits, my lord, all the service benefits are there, my lord.
Pensionary or service benefits?
My
Oh,
lord,
you want
service benefits
service as
because
benefit.
and retiral benefits
Was
because
a
this is
dismissal.
consequential, my lord.
So
Because at that time, my lord, I was in service 2007 dismissed and my superannuation year 2015, my lord.
What is the date of dismissal?
Dismissal 2007, my lord.
And you have been given the benefit of a criminal trial finding in which year?
My lord, that is 2024 December, my lord.
7 December 2020.
My lord, all the matters were pending for long, my lord. Even this
7
writ
December 24, finally you were acquitted.
my lord,
And then the trial court gave you a benefit of that acquittal.
my lord. I have got
What
that
is
benefit.
2007 is the dismissal order.
Dismissal order.
What is the date of your superannuation?
Superannuation in the year 2015, my lord. 2015.
Date of dismissal.
2015, can you give us the date?
My lord, right now I don't have the month subject to correction, my lord. That is July 2025, my lord. 2015, my lord.
Sorry, please.
My lord, year is 2015, my
You
lord.
don't have the date.
My lord, I have to check that date, my lord. Otherwise, it would might be wrong, my lord.
Anyway, so 2015.
2015, that's for sure.
So you did not challenge the dismissal in 2007?
Yes, my lord. My writ petition is of 2007, my lord. Immediately, my lord. Within, my lord, 2 months, my lord, I have filed the writ application, my lord. Thereafter, it was pending for long, my lord. In the meantime, once matter was dismissed for default, that was restored.
Let us see your prayer in the appeal. Where is your prayer?
My lord,
MAT 2038.
yes, my lord. My lord, may I submit one thing, my lord? Since I am led by Mr. Owen Banerjee, my lord, if my lord fix the matter on some other day, my lord, otherwise, my lord, it is
Just now, learned
Yes,
counsel
my lord. Yes, my
said
lord.
so you are proceeding.
No, my lord.
And we are proceeding also because you don't
This is a difficult position, my lord.
I can't for that reason, my lord, because the benefits of
You made no such prayer, therefore we are proceeding. We have nothing to wait for. Just give us 1 minute. Let us see the
my
page. That should be in the memorandum. MAT 2038 memorandum. Section 5. His claim is only limited to back wages. Very well, we'll see. It is submitted by Mr. Swenson.
Put him in difficulty.
No, you said so, but he is continuing, so we would also.
But later we all,
I'm sorry,
to the junior stages, your lordship has gone to junior stages. But when the repercussion happens, I know what happens.
I said I would have jumped for that if I.
Milo, grateful, Milo.
I wouldn't be kind if Mr. Oil Manager would have been here.
Item number 17.
Not for the grandfather.
But can it be posted day after tomorrow? I have some difficulty today, madam.
First.
Item number 18.
Item 18, my lord, I am appearing for the appellant. My learned friends were submitting on the last occasion, my lord. It was their turn to give the opposition. No, not my lord. Affidavit in opposition. They were arguing, my lord.
Lastly taken up on 24/7.
Yes, my lord.
No, that day nobody appeared for anyone.
My lord, yes. On the previous occasion, my lord, my learned friend had started his argument.
Oh.
The issue was, my lord. Oh, sorry.
Revision, whether it is automatic or not.
My lord.
So they claim that it was the once the allowance are inherent in the wages.
My lord.
They were trying to submit that the allowance is inherent in the wages.
My lord, yes, my lord.
Separate order is not required.
Their argument was that since, my lord, overtime allowance is defined in the Practice Act as a part of the wages, payments of wages acts, provisions of payment of wages act will follow. My lord, since they had taken that argument, I would have, my lord, argued that payment of wages act, my lord, contemplates a provision by which the delayed wages have to be claimed. One has to go to the controlling authority then, my lord. It's enshrined in the act.
You are for the
appellant authority, my lord.
There is none to represent the respondent. Stop. We adjourned the matter 2 weeks.
Second settlement. I'm grateful, my lord.
Item number 19.
19 minute, I appear on behalf of the appellant minute. Last occasion, Lordship were pleased to direct the writ petitioner respondent
Provident fund gratuity paid.
Provident fund has been paid on 2nd August.
And gratuity?
Gratuity, my lord, ALC called for to hearing. First day, petitioner not appear. And second day has been fixed on 1st September. After hearing, it will be discussed. This is the procedure of the ALC, not the ECL. ECL also must be appeared on that hearing date.
No, but you said you have already forwarded the gratuity deed.
Yes. Already forwarded.
Why it has to go to the Labour Commissioner?
Labor Commission, because in spite of several requests, the rate petitioner did not came to the office to collect his gratuity amount.
But last time he said that he will go and get it.
False statement, my lord. Wrong statement. He did not appear before.
He will not go to get his own dues.
Yes, my lord.
He will not go to collect his dues.
Yes, my lord. Not only that, my lord. Provident Fund is concerned, there is some documents to be produced. That also not produced within time. That also produced after long time. And accordingly, it has been disbursed.
None appears for the respondent.
Second.
I didn't.
Lord, I am for the petitioner respondent. Appellant, my lord, here. Second section.
Appellant.
Lord, I was trying to make out a case, my lord. At the very outset, I will be very candid, my lord. A similar order was passed by the Honorable Single Judge that was directly went up to the Honorable Supreme Court. It was tested before there. Honorable Supreme Court clearly held that there is no infirmity in this order. And I have challenged that similar order, my lord. This is the order passed in another. This was tested before the Honorable Supreme Court. I have two copies of. Sorry, my lord. I have
But on the last occasion, it might be in your lordship's file because it was given. Might be in your lordship.
You had given it. Then it must be here.
Yes, my
Comrade Bush.
Yes.
And this is
the order of His Lordship Justice Arvind Kumar and Justice Varale.
Is of SLP, man.
Yes, we have got it. So basically paragraph 9 and 10 is important. 9 and 10 of the impugned order.
Impugned order, my lord.
That has to be carried out now in terms of the
4. My lord.
So do it.
My lord, this my lord is having this order of Honorable Supreme Court passed in SLP, my lord. My lord, my only simple. I may be running a very bad case, my lord, at the very outset, my lord. Let me be very candid. But still, my lord, I have some duty towards my client, my lord, also. Because this order of Samrat Mukherjee, Samrat Goswami, did not see the Honorable Division Bench of this Honorable Court. It went directly to the Supreme Court, my lord.
That's because you are not complying with direction of the apex court.
No, this is in a different case, that is.
Correct.
In a different, no, my lord, Samrat Mukherjee.
Where is the scope for this argument? You are a state under Article 12.
My lord.
You are not here to make unnecessary litigation.
No, my lord.
You are not a private individual that you make an attempt to somehow distinguish, knowing fully well that it is covered. This is expected from a state.
Last, my lord, may I be permitted, subject to my lord sanctions. Only I was referring to this judgment of my lord, of the Honorable Supreme Court. My lord,
we will not look into. Why we should look into the Honorable Supreme Court judgment right now? There is a direction by the learned single judge. Same direction passed in another case affirmed. Now you want us to look into the Supreme Court order. Wonderful. So then you will travel all the way up to the Supreme Court. That's precisely what we are saying. So you are a state, you are fighting at the expense of someone else, so you will indulge in such litigation.
I may be wrong, my lord, subject to correction. I have a very small submission, my lord.
Look to paragraph 17 of the Samrat order.
Yes, my lord.
What is the difference?
No, there is no difference. I'm saying, my lord. But only one submission.
Then,
my lord,
if there is no difference, then what submission?
Rejects my submission, my argument. Only one kindly allows me, my lord. My lord, this order was no reason was assigned. That was my case, my lord. No reason has been assigned by the Honorable Supreme Court. So I am taking shelter of this judgment of Honorable Supreme Court, my lord, passed in Khunayamad versus State of Kerala, my lord. That is my only case before my lord. I do not have any other case. Yes, my lord, it is true, my lord. The Honorable Supreme Court has affirmed a similar order. Similar order has
identical.
Identical.
Yes.
Identical order.
Identical order.
But since no reason.
And I have the identical objection. That bank does not become a state.
My lord, here it is said that we find no ground to interfere with the impure.
What was the objection raised in Samrat by the bank? See,
Samrat Mukherjee, so Samrat Goswami's case, the objection.
What is the objection raised? Read.
I was there in the Samrat Mukherjee case. My lord,
identical objection, identical order, and therefore now you will argue.
Since no reason was assigned, that was only case before my lord.
Where are you arguing?
In where my
we don't know how to make such submissions.
My lord, are pleased to direct my learned friend to go consider this judgment also, which I placed in the last question. I placed before this judgment before my lord.
There is no way, as a Article 12 authority, you can make such a submission. You are not here to litigate.
At the very outset, I said that I may be running a very bad case, my lord.
No, but then see, there is something expected from a state council representing an authority who is an Article 12 authority. This is not the way to argue, as if somebody is taking something out of some individual's pocket.
No,
this is not the way. But the same objection you raised that we are blank, we can't become within the meaning of state. The same objection turned down by single judge, order of the Supreme Court rejecting the SLP, and now you want to argue the same thing again.
Not against same thing, only one.
No, you want to argue exactly the same thing. That you are not bound because you are not state government.
No, not that.
No, that is the only submission made by you before the single judge.
My lord, before my lord, I only have.
No, ultimately to what avail? To sustain that point that you are not covered. However you become, ultimately you are trying to sustain that point that you are not bound. How can you? That's precisely what we are saying. In whatever way you argue. And can you, in every case, raise this objection for the sake of objection? Have you implemented the judgment of Samrat Goswami? No. You have to. You have no option.
I have to.
This is unnecessary litigation. This is unnecessary litigation by a state authority.
This was filed prior to Samrat Mukherjee's judgment in Supreme.
But this submission you are making after Samrat Goswami is allowed.
I was very candid.
After a Supreme Court has rejected your appeal against that, you are making the same submission that I am not a state government.
I am very candid before my lord at the very outset. I only.
Sir, we understand what you are saying, but an argument for the sake of argument. We are on that. Whether it is to be indulged in by a state authority. That's the only thing. Ultimately, you will
my
you
lord,
will rely only on that point that I am not a state government.
yes,
Does it lie in your mouth to say this
even
now?
if I succeed in saying that this no reason has been assigned by Honorable Supreme Court,
Ultimately, it comes down to the same
boils
thing.
down to the same point.
That issue is now over. And you admit that the case of Samrat Goswami is identical.
Well, there is no scope to differ.
So therefore,
There is no
we are
scope to
saying
differ.
on the last day you had shown that judgment. But see, ultimately, you will have to wriggle out of something which you cannot now. You are bound to implement that. Paragraph 47 of the judgment. How many other such matters are pending?
As of now, my lord, these two matters, Samrat Goswami and this matters.
Only two.
And one of the there was
Some
one of
other
the
matters, my lord,
PNB also.
PNB there is, it has been.
You are appearing for PNB also.
My lord, in case of PNB, my lord, after filing, it has been given. That has also been that one PNB.
But it is a different bag, my lord. Altogether.
No, they are all authorities under Article 12. That identity does not make a difference in the litigation policy which a state authority should be adopting in larger public interests, because ultimately you contest on public money. So there should be a scrutiny of what is to be litigated and what not to be litigated. And somebody has to take responsibility. Judgment. What do you want to heard the
The other side. I'm the respondent, not my appeal.
They will be hearing a different voice.
Oh, item number 81. I actually was looking for your lordship. Your lordship waved at me, and then I couldn't find your lordship. Your lordship probably had different perspective, different voices, different places. What can be done?
Attitude. Appear for the applicant. Yes. Respondent was lordship appointed under compassionate ground lordship. Appointed under compassionate ground lordship. During his service tenure lordship on 11th March 1998 lordship, charge sheet was issued. First charge sheet lordship, the 19 dormant pensioners account he has been activated.
Deactivated.
Second is that lordship, 17 dormant accounts lordship he has paid.
So the charges have nothing to do with his appointment.
And third one is lordship, due to that lordship there is loss of 38 lakhs. Inquiry was lordship conducted by the inquiry officer. The delinquent along with his representative appeared before that. In respect of first charge lordship, it is partially proved. In respect of second charge, that is proved. In respect of third charge, that not proved lordship. Thereafter, lordship, disciplinary authority passed the order lordship disagree with the report of the inquiry. And lordship, inquiry report along with that lordship, the decision of the disciplinary authority was forwarded to the delinquent lordship, sought for the written objection. Thereafter, written objection was there lordship. Before passing the final order lordship, personal hearing was given along with the defense representative before the
Personal hearing by the disciplinary authority also.
I'm sorry, personal hearing along with the defense representative was given before the disciplinary authority. Thereafter, lordship passed the order of punishment, dismissal without notice. Thereafter, appeal was preferred and that appeal was dismissed. Against that lordship, delinquent lordship filed writ petition and that honorable single bench lordship passed the order lordship till the order of the disciplinary authority as well as the order of appellate authority has been passed and directed the disciplinary authority to pass the case order lordship. My respectful submission before that lordship, kindly see the charge sheet lordship. Charge sheet was issued lordship under the gross misconduct. And even if lordship one charge is proved in the lordship inquiry, it is sufficient to punish the delinquent lordship because that out of 3 charges,
So are you submitting that you will only proceed against him for that charge which has been proved?
lordship, only one.
You will not take into consideration the other charges?
Lordship, one charge, if lordship principal.
No, if and but for what you are what the submission you are making, out of 10 charges, maybe 5 are proved, 5 not proved. You say even if 5 are proved, then he will be liable for a gross misconduct. So then is it your submission that you are not proceeding against him for the remaining 5 charges?
Remaining charges there, lordship, because lordship there.
Then why you are making this submission?
Lordship, only thing is that they are saying that
forget about what they are saying. We are asking you what you are saying.
One of
you have been relegated to the stage of action taken on inquiry report. This you have been relegated to that stage. If you don't want to consider the other charges which the inquiry officer has exonerated him from, then if you say so, we'll pass appropriate orders right now. You proceed against him. If you want to proceed on the basis of those charges also, then you will have to show why the Honorable Single Judge order is not sustainable. That's hardly relevant that the one charge itself will constitute a gross misconduct.
Principal order, that's what I'm submitting.
Sir, to what avail? That we are asking you. There are so many laws, you cannot argue everything. Only something which you derive benefit from, then you should place it. Yes.
Kindly see the order of the
Show us the disagreement note, please. Come to the disagreement note. There is no cross appeal. There is no cross appeal. So show us the disagreement note then. Let's see.
Order of the punishment. Order of the punishment, page 200.
Sir, disagreement, please.
You will find page 227.
227.
That is the number 2.
One of the findings is at 243. Where is the other finding? This is regarding that charge which has been held partly proved and one has been held not proved. That 245. Yes, so where is the charge? Just it shows the two charges which was partly proved and not proved.
That we will find page 55. Third. There's a first volume.
This is the charge memo.
This is charge memo. Dated 25th October
And
2017.
where is the articles of
55 page 55 lot charge sheet in the top lot. Whereafter charge 1. All the descriptions of 19 dormant accounts.
and where is the provision which governs the action taken on inquiry report? Service regulation must be. Where is
Is bipartite. He is governed by the
Oh,
He is the workman. Not
he is a clerk, clerical cadre.
He is governed by the 10/4 2002 bipartite.
Provisions are more or less the same. There is hardly any difference. Where is it? The relevant part of the bipartite settlement which deals with action taken on the inquiry report?
Starts from clause.
It's not on record.
Lordship. May be permitted to hand over. This is the proceeding. The procedural clause 12 lordship. Procedural cases lordship is entirely mentioned. And according to this procedural lordship, the dependency representative was given lordship. He has deposed delinquent also lordship. They were exhibited at their lordship. On the part of management, there are more than 19 exhibits.
Which provision deals with the disciplinary authorities' exercise of discretion?
On the clause 1 lordship, it is mentioned that final order shall be passed after the consideration of all the relevant facts and circumstances. Lordship will find page 133. Lordship.
That we are looking at. That we have seen. No, clause 11 and 12 is the relevant clause dealing with the departmental proceeding. Yes.
Respect of the disciplinary proceeding. Up to the provision of appeal also. Up to the provision of appeal also mentioned.
Yes. So, how do you sustain the findings of the disciplinary authority?
So, entire inquiry report was considered by the disciplinary authority lordship, including all the witnesses lordship.
all the witnesses will, whatever the deposed before the inquiry officer, that was already quoted in the order of the disciplinary authority, Lordship. It is not a stereotype of 1 or 2 pages order. It's a long order, Lordship. The disciplinary authority has considered all the aspects before the inquiry officer, as well the witness deposition of the management witness, as well as the depositions of the defense representative also, Lordship. And not only that, submissions which were made and written objections which are made by the delinquent, Lordship, that has been already been considered by the order of the disciplinary authority.
Including the conclusion of the inquiry officer, that has also been quoted. Everything. But after that, what is his consideration? That's what we are asking you. He takes note that, look, this is the material which was placed before the inquiry officer. These are the submissions made by both parties. After considering the entire thing, the inquiry officer has arrived at such and such finding. But I conclude like this. That I conclude like this is on the basis of what material? There are only 2 pages containing his conclusion of out of that elaborate order. One is at page 243 and the other is at 245. Prior to that, it is just a record of proceedings from the inquiry. There is no application of mine prior to this. The findings start at page 243. Which material is being relied upon to arrive at a contrary conclusion or to convey a point of distinction? And without reference to any material, can a conclusion be recorded? You are correct when you say it is a long order. It is a long order. 40, how many pages? 40 pages. No.
Kindly see page 244, Lordship.
Yes, please.
Clause 3, Lordship. As per the records, the cancellation of LTS were not made under the initials of 2 officers and denominations. Currency notes paid by the CSE not recorded on the reverts.
No, that is not the disciplinary authority's finding. This is from the inquiry. All this is from the inquiry, sir. His finding starts at the next page.
Page 45.
Yes, small Roman 3.
Kindly see that Anderson observed that CSE had been working in the cash department many occasions and performed his tasks in efficient manner. CSE, although marketing staff of the branch, but his service can be equally utilized in any section of the branch, including the cash department as deemed necessary. In the instant case, the question cash payments were made by the CSE of 17 numbers of disputed. The instant case withdrawal slips in 11 out of 17 transactions. LTF of the pensioners were not cancelled by 2 officials of the branch, and in one case, LTF customers was not cancelled by any officer of the branch. All the question withdrawal slips were of the value of ranging 52,000 to such and such, but in most of the cases, LTIs of customers were cancelled. And the procedure was not followed when he dealing with the cash department. And the inquiry is in hyper technical manner, Lordship. This is to totally overlook the thing, Lordship. And thereafter, Lordship, kindly see. During the entire period, after 2 lines, during the entire period, currency notes paid were not recorded on the reverts of the withdrawal slip. During the entire period of nearly 10 months, the CSE never interacted with the officers of the branch to inquire about such shortcomings. He's totally silent. When the bank itself voluntarily inquired about the matter, then it was detected. But prior to that, Lordship, his malintention is there. He never mentioned that. That is why Lordship clearly mentioned after 10 months. After 10 months, is totally silent. This was not considered during the period of inquiry. Your Lordship is already well aware, Lordship. Even a single penny is there, Lordship, during the banking service. That is completely upon the public money, Lordship. Depend upon the trust, Lordship.
High degree of integrity and devotion and dedication to work is required. Any material has been considered in this paragraph. There are how many documents?
And second paragraph, page 45. It has come in the records of the inquiry that the pensioners were not operating their.
There is an endless list of documents accompanying the charge memo. starting from page 61. Which out of these list of documents, which document was relied upon by the disciplinary authority to arrive at a finding at variance with the findings of the inquiry officer? Any of these documents are considered in that paragraph which you are relying upon? So the learned single judge has given you an opportunity, you consider it. What has been directed? He will get, he will be treated as in regular service in this period, or he will be treated as under suspension?
The learned single judge also directed to pass a fresh order from the by the disciplinary authority. Up to inquiry report, it was clear. If you lordship kindly consider in order.
We are asking you, in this period, he is to be treated as on suspension or in service?
No, lordship, that is not mentioned. That is not mentioned in the order.
Not mentioned.
No, lordship. Kindly see, lordship. Page. This is third volume, lordship.
If not mentioned, then he will be under suspension.
Operating portion is lordship. Page 382, lordship. Paragraph 52, lordship.
Yes.
Decrement order of the disciplinary authority, lordship. Order of the disciplinary authority, disagreement order.
So how are you agreed? What is you are agreed by what part of the honorable single judge's order?
Matter was remanded back to the disciplinary authority. Lordship.
You don't want to have a relook.
Again, we have to because Lordship, it is a matter of the bank, Lordship. The officers, this is a public trust and money, Lordship. Against these three charges, Lordship, there is money involved 38 lakhs more than at the relevant point of time is the Lordship there.
That's why the honorable single judge said you have a relook. You examine it with reference to the material. He is continuing in suspension. You still have the option of establishing those charges or disagreeing based on the material. So,
Order of the
and there no time has been fixed for this exercise
time is
within a period of 4 weeks. And the order is of which date?
March 2026, the order was passed. Appeal was
Because of this appeal, you have taken 5 months, which you could have done in 4 weeks. So,
page 245, that is agreement order of the disciplinary authority. Let's say all the 17 numbers of leadership, that was already mentioned in the report of the inquiry and all other exhibits. Lordship will find page 70. This was also considered, Lordship, because 17.
see, that is why the inquiry officer held you guilty, held him guilty. Because at least the fact that he has not mentioned the currency denomination on the reverse of the payslip, that has been taken cognizance of by the inquiry officer as well as by the learned single judge, because there is no explanation offered for that. That may be a mandatory procedure or precedent or norms in the banking transaction. So that he has found, plus the entries have been made through your user ID. But the processing of the pay slip, the revival of the accounts, it is a collective responsibility not possible by a single person.
That 4 persons already got some charges. Against that 4 person, disciplinary person is also already been initiated.
What are you saying, sir?
None of them were.
They are the Sudipal and.
Please see paragraph 44.
None of them has been.
Please see paragraph 44.
The petition.
Please
I'll
read.
come back.
Please read para 44 of the honorable single judge order. You have got paragraph 44. No proceeding is initiated against anyone else. And even if it is initiated, the individual roles have to be identified in each one's inquiry. Some slips, the LTI is cancelled by one employee. In some slips, the LTI is cancelled by 2, in some by 3, in some not cancelled at all. So who is responsible? Therefore, the opportunity is left with you to still take a better view of the matter and rely upon the material. Just see the number of documents. We don't know how in any inquiry you can consider this many documents. Page 61, it starts 19,
Out of that,
then 18, then another
19 dates, but with various subjects.
7.
Various subjects.
No, they are all documents, sir.
These are the documents.
They are all documents.
In numerical 1 to
This is the list of documents. And where is the list of witnesses?
4 witnesses.
Where is that? 70.
You find the one there are 4 of the management side. Right. In ME1,
Yes, there are 5 witnesses. MW1 to MW5. This has all happened in Kharagpur branch. What is your submission? So everything is in order. Charge memo issued, inquiry conducted, witnesses examined, documents placed, opportunity of examination, cross-examination, difference by an order indicating note the points of disagreement, and therefore there is no occasion to interfere. Yes.
My lord, I will not trouble your lordship much, my lord. First of all, my lord, lordship will kindly take page 10 of the stay application, my lord. I usually do not take these points, but since, my lord, grateful to my lord Junior Mr. Banerjee, lordship will kindly see the date of affirmation, my lord.
Yes.
No section 5. Intra-court appeal 30 days. I do not know, my lord. Taking this point of my sense.
No, is there any report regarding a delay?
We have not been served. We have served much later. 10th May, it has been affirmed. 10th of March.
maybe not non-existent first April 2026.
It has not even been mentioned, my lord, in the memo of appeal, my lord. And the memo of appeal, my lord.
Yes. The memo is within time.
Within time? Fair enough. Then it's fine, my lord.
They must have filed the stay letter because there is no report. There is no report of delay.
Probably.
April. The memo was filed.
How do we get the date?
But the copy of the memo that has been served to us, my lord, does not have the impugned order. Only the memo has been served to us. No impugned order was served, and that is on instruction. I'm saying, but I will not take that point again.
21/4/26 it was filed.
I'm sorry, my lord.
21/4/26 it was filed.
Still belated. 10th March.
So there, 10th March, that means maybe 10-15.
I'm not taking the
Meaning the certified copy because
I'm giving up that point.
There is no report of delay.
I'm giving up that point. Well, I thought I should, my lord, point it out, my lord, but I'm giving up that point. Well, Lord will kindly take the impugned order once, my lord. And start at 356, volume 2,
March and
volume 3, my lord.
delivery is 7th.
So this time it's 19 days. It's 7 days. 26 days.
26 days in certified copy. Making over the certified copy. So therefore, probably no delay. Yes. What else?
My lord, kindly take the impugned order once, my lord. Page 371, volume 3, my lord.
Internal page of the impugned order?
16.
Yes.
My lord, I would, my lord, strongly, my lord, ventilate, my lord, my support in favor of the impugned order being passed, my lord, in my favor, my lord. On the simpliciter ground, that will be, my lord, threefold, my lord. First, my lord, the inquiry officer, while, my lord, dealing with the investigation, records that in the report, my lord, records that it should, as has been rightly pointed out by the bench, my lord, that, my lord, this entire process of, my lord, making the account government to active, then putting the money there, it's not one person's job. Has been rightly pointed out, my lord, and I join issues with your lordships on that, my lord. no other single person, my lord, and that has been recorded, was brought to the docks, inquired. Well, I would say, my lord, if I take a step further and say, my lord, I would say that because I was probably the weakest link in the entire chain, I have been, my lord, castigized, my lord. Otherwise, there are no evidence against me. The most important thing, my lord, the third charge, that is the interpolation, which accordingly, my lord, allegedly I have done, which, my lord, in allow the money to get into the account and then being withdrawn. That is the main offense that has been canvassed out against me. It has not been proved. They themselves say, they themselves call their handwriting expert. 115, the handwriting expert. He says that the signature bearing in the menu, which is honestly the signature of mine, giving sample does not match. They did not take on note of that. All that were recorded in the inquiry report, and the inquiry report then holds, my lord, the first charge and the third charge are not proved, second charge is partially proved. Now, while the disciplinary authority, my lord, seeing the final order, my lord, as as my lord pointed out, my lord, there is no indication as to why the disciplinary authority has disagreed only on these counts, or on what counts it has disagreed. My lord, if your lordship takes the impugn order, my lord, from paragraph 20, my lord, I will place 2-3 paragraphs, my lord, not much, my lord. Starts with undisputably, my lord, para 20, my lord. Judicial.
Before we proceed, have you gone through that bipartite settlement?
No, I have not been served with any copy. They have not disclosed this on the trial court. Contrary, they took a point, and Lordship will find it from the record. They initially took a point of maintainability, saying that he is a workman, so he should be governed under the labor legislation. There is another judgment of a coordinate bench. Well, rightly or wrongly, well, I was a party to that proceeding as well. That is a reported judgment, Produt Mitra versus United Bank of India, my lord, reported in AIR and SCC, my lord. We gave that citation, and not a single bench, when her lordship, her ladyship had the determination, my lord, held in favor of the writ petitioner that this writ petitioner is maintainable. Nowhere at that time and throughout the process, when they argued this matter, they mentioned bipartite or anything of that sort. Nothing was mentioned.
They have not raised today also. Why we are asking you, in almost every service regulation that we have seen,
yes, my lord,
there is a specific clause dealing with the action taken on inquiry report.
Right.
And normally it is couched in the same language that the disciplinary authority, after examining the inquiry report, will record his own findings, indicating the points of disagreement with reference to the material on record. Right. And then he will give an opportunity.
Absolutely.
And after, so where is that provision?
Because I do not have the copy, so I won't be able to.
So participated in a proceeding under that procedure only. Therefore,
I have no now. Point is, my lord, I have no difficulty in participating, my lord. Now, the real problem I will tell you is not legal, not departmental, but more psychological. Go back. They will be sitting with a V for vendetta. Let me be very candid, my lord. They're lost in the single bench. They come up in appeal. Appeal court, if I assume that appeal court does not reverse the direction of the single bench, my lord, sends me back, I will be an absolute sitting duck over there. If they have decided to vindicate me, initiate proceeding against other 3 persons whom they say are also involved, they will definitely, my lord, find out a way, my lord, to again incarcerate me, my lord. It's pure psychological, nothing legal out of it, my lord. Purely psychological, my lord. Having said that, I have no difficulty in going back again. I say this, I reiterate this, my lord. It will happen to me, my lord. In spite of that, I will take that chance. Now I leave it to your lordship, my lord.
Yes, paragraph 20, you are
yes. Undisputedly, judicial review encompasses legality, irrationality, including reasonably unreasonableness and procedural impropriety. The doctrine of reasonableness gives way to doctrine of proportionality. Judicial review aims to prevent arbitrariness, irrationality, reasonableness, bias, and malfeasance. Article 14 requires fairness in state action. While judicial review is generally limited to the decision-making process, a decision that is perverse, irrational, and grossly disproportionate falls within its scope. In this case, my lord, 3 will, my lord, squarely applies, because when the disciplinary authority, my lord, goes back, my lord, and says that no, I do not agree with what the inquiry officers have found, and proceeds to dismiss me from service, it nowhere in its recording, as rightly has been pointed out by your lordship's, my lord, records on the basis of which documents, which the disciplinary authority felt that the inquiry authority has completely gone tangential, completely went berserk, and have not considered that particular document, which would otherwise have or had convicted or held the petitioner guilty of the charge 1 and charge 3, which are not proven. So if my charge 3 is not proven, my signatures are not proven, everything falls flat, my lord. Just because, my lord, I am the weakest link in this entire, my lord, process, a charge that has not been proven after considering every single document, the disciplinary authority goes back and says, no, needs to be dismissed because I have considered what? Not spelled out. If this is not unfair, my lord, I do not know, my lord, what can be more unfair, my lord. Well, kindly come to paragraph 23. I will skip 2 more paragraphs, my lord. Internal page 17. In the peculiar facts and circumstances of the case, upon evaluation of the evidence brought on record by the management and the petitioner, the EO, or that's the inquiry officer, I'm sorry, returned his findings dated 27/4/2018, wherein it was recorded interiorly as followed. Inquiry, any nexus or unholy alliance of the charge-sheeted employee with Shudeep Dash, PF number such and such, staff officer, or swell branch manager was not established. That's a finding. That was to establish that the CAC has misappropriated 38,67,000 odd, amounting to 17 disputed withdrawal slips, which were paid by the CAC under his user ID, etc., instead of paying accounts to the respective pensioners, stroke persons appear before the CAC's, the charge sheet of employees cash counter for receiving payments. Fourth, most importantly, based on the aforesaid discussion analysis, also discussions analysis made under charge 1 and charge 1 Roman 2, and on the basis of the allegations made against the charge sheeted employee, we did para 4, page 3 of the charge sheet dated 75/10/2017, and the relevant portions of the corrigion dated 1/12/2017 stands not proved. And I go back to the same place. The same oven I will be thrown into. This is the finding of this honorable single bench, my lord, and they had no answer to that. And, my lord, interestingly, my lord, paragraph 28, my lord.
No, this is the finding of the inquiry of
yes,
not the single judge.
Yes, the single judge has recorded this finding, has taken a note of this finding. And page, para 25, I'm sorry, my lord. In the inquiry report, it was specifically observed that the applications of the pensioners and their KYC documents were not available in the branch, on the basis of which the petitioner was alleged to have entered data in the financial system of the branch. It was further noted that the management did not produce any designated officer of the branch, such as the branch head or the manager administration, who were posted during that relevant point of time. Is it not necessary? Something happens under my nose and I was never called for an inquiry. But I have never come across such a situation, my lord. It was further noted thereafter, my lord, been issued to the CSC for carrying out the said task. No instruction has been issued to the CSC in the absence of any documentary or evidence. It was found to be extremely difficult to ascertain the correct factual possession, my lord. And the disciplinary authority says, no, you are completely wrong. He is guilty because I want him to be guilty. Can't be a better case of vendetta, my lord. Can't be, my lord. I'm sorry to say, my lord.
Yes.
Let continuously, paragraph 36, my lord. I will take the culmination of all this, my lord, findings, my lord. I'm sorry, my lord. Come to my lord, para 32 first, my lord. The disciplinary authority disagreed with the findings of the inquiry officer and recorded that in departmental proceedings applicable standard of proof, that is a preponderance of probability and not proof is beyond reasonable doubt. It was further observed that the fact that the transactions were executed to the petitioner was sufficient to prove. Unbelievable. But I have some experience in banking, well, not in banking services, but I usually take time off to go to the banks for withdrawals, my lord, and deposits as well, physically. Usually what happens, my lord, my customer service executive, my lord, at times, if that lady is not in her seat, she requests somebody to enter her ID just to facilitate the branch movement. Somebody else comes in, enters the ID, and then the lady comes in, puts her password, walks away, and go to some other work, and then the forms and all that thing, and the passbook update, etc. happens. I have seen it. Right across, I have a account, my lord, in the Shambridhi Bhavan, my lord. I've seen that, my lord, because banking staff, my lord, they are engaged in various other activities also, my lord. So it is not that, say, the time I go or time somebody goes, my customer service executive may be at a lunch period, at a lunchtime, maybe somewhere else, and he was never designated in the cash count. He was recruited for some other job, and he was deputed in another job. His profile was completely different from what he was doing in the branch.
He was an accountant.
No, he was a management associate. He was sent to a cash job. Since I have a staff, somebody is not there, you please go and manage the teller. Happens everywhere, my lord. Happens in this court. I am not present in before this honorable bench. I am here for another honorable bench. My learned junior comes in and takes a time on behalf of me, even whether he is briefed in the matter or not. We did not all did it in our lives. It's exactly like that. Somebody is there, a personal request, please go and do this for me. And he was sent there, his job profile, kept there. Somebody hatched something out, monies were gone, and they had to find somebody. And there I was, sticking my neck out, right to be guillotined, my lord. Well, Rule 7, my lord, I'm sorry. Regulation 7, my lord. I'm grateful Mr. Ahmed was kind enough, my lord. Action on the inquiry report, my lord. Regulation 7(1) of bipartite, my lord. Disciplinary regulation of the bank, my lord.
No, that will not apply.
That will not apply.
That is
Fair
for
enough.
managerial staff. This case is covered by the procedure established in the memorandum of settlement.
Fair enough, my lord.
Bipartite settlement under section 18(3) of the
I will come back to the impugned order, my lord. Paragraph 33, my lord.
We don't know why it is missing. That provision is there in every rule and regulation.
Maybe
I have not been able to find it.
It may so happen, my lord. Sometimes, my lord, while making these things, my lord, they think that they have put it and they forgot to put it, my lord.
It must be there. I have not been able to find it.
Can be a human error also, my lord. The draftsman, my lord, not by us. Its findings regarding charge 1(1).
And even if that provision is not there, Kunj Bihari Mishra is there. That procedure is laid down by the apex court in the case of Punjab National Bank versus Kunj Bihari Mishra.
No, that is, my lord, again, my lord, the service regulation has a definition of officer employee. Well, its definition means a person who holds a supervisory, administrative, or managerial post in the bank, or any person who has been appointed and is functioning as an officer of the bank by whatever designation calls, and includes a person whose services are temporarily placed at the disposal of the central government. I'm not on that, my lord. So, my lord, somebody, my lord, taken in an administrative and a management position, my lord, will come under, my lord, this definition J and the officer employee, my lord. 3J.
Normally, the class of officers are categorized scale wise, and from a particular scale onwards, they are treated as supervisory or managerial staff.
True.
They have said that you are not a managerial or supervisory staff. We have nothing on the contrary. If you can show, then we can rely on the regular. Otherwise,
I'm just showing.
Treat as if it is governed by.
Yes. I'm not. I'm just, Millet, since Millet has been brought to my notice, Millet, I felt, Millet, I should also brought it to the notice of the bench, Millet.
Because officers start from a particular scale.
Yes.
Below that, they are all.
Absolutely, yes, Millet. Millet, in paragraph 33, Millet, if I come back to this, Millet, its findings regarding charge 1(1). The disciplinary authority observed that the presiding officer has examined management witnesses whose oral evidence, in his view, substantiated the charge in the inquiry. Oral evidence, not supported by documents. He further said that although no supporting documents were available before the charge sheeted employees for entering the relevant data for activation of the account, the certification of the branch head that no such document existed in the branch records that the charge sheeted employee has acted in an unauthorized manner. The disciplinary authority also note that most of the data has been verified by the SOL. SOL is what's the full form? Well, I do not know the full form of SOL. Well, indicating
you have to tell us. You can't say
I'm sorry, Well. So I'm sorry, Well. Oh, that's a comma. But I'm very bad with accuracy, full forms. Well, I'm very, very bad.
But you have the benefit of finding it out immediately. We can't. SOI or SOL, what is it?
Statement of intent.
Okay.
Indicating the absence of any instruction from the branch officials. According to him, these circumstances reflected a ill motive on the part of the CSE, the charge sheeted employee, and therefore the view taken by the inquiry officer is not justified. But the more I read,
none of these persons have come forward to say that their pension amount has been not credited or not paid.
No.
There is no complaint. No. So how it has come to light? What has led to issuance of the charge memo? From audit or what is it?
That's from an internal audit.
All right, very good.
So, Millet, the more I read, Millet, this finding,
yes,
the more I read this finding of the disciplinary authority, Millet, the more, my lord, I feel, my lord, it was probably he was bestowed with a charge, my lord, with a responsibility, with a duty, my lord, to, my lord, crucify me, my lord. No documents, on oral evidence, I am satisfied, my lord.
Which oral evidence?
Oral evidence of the management witness. That they have recorded.
That we have seen. Which oral evidence he has not.
No, also
and
he
what
has
is
not.
the content of that evidence? which he
Precisely, my lord, I am grateful, my lord. My lord, I need not take your lordship's time much, my lord. I think, my lord, if your lordship, my lord, take some time from your lordship's busy schedule and just read 3-4 more paragraphs, my lord. I'm not placing 34.
Which paragraph you want to place?
34, 35, my lord. I'm not placing 36. I will place, my lord.
Place it. Yes.
Therefore, a comparative reading of the findings of the inquiry officer and the disciplinary committee authority reveals a clear divergence. While the inquiry officer observed that the management has failed to produce the documents on the basis of which the charge-sheeted employee allegedly carried out the preliminary work of entering data in the system for activation of the accounts, and held that in the absence of oral documentary or circumstantial evidence, it would be illogical to infer any dishonest intention on the part of the charge-sheeted employee. The disciplinary authority, by merely paraphrasing certain portions of the inquiry officer's report and the written submissions of the charge-sheeted employee, concluded that oral evidence adduced by the management substantiated the charges. The disciplinary authority further treated the absence of documentary evidence as corroborative of the allegation of the charge-sheeted employee was acted in an unauthorized manner by entering the dates for activation of the concerned accounts without undertaking any independent discussions or evidence on record. My lord, I pause here, my lord. I stop here, my lord. Because I need not, my lord, take your lordship's valuable time, my lord, to go on reading this, my lord, which will, my lord, show, my lord, evidences galore that the disciplinary authority was given a one-point agenda, was on a one-point agenda just to, my lord, crucify me, my lord. And I still say, my lord, with conviction, my lord, if your lordship so still feels that I should go back, I'm ready to go back. But I exactly know what will be my fate. That is all, my lord. I'm no. My learned friend showed this, my lord, bipartite, my lord, regulation 10. In all cases, regulation 10, my lord, in all cases in which
clause of the
clause 10, my lord. But in all cases in which action under clauses 4, 6, and 8, 6 is gross misconduct, my lord, may be taken, the proceedings held shall be entered in a book kept specially for this purpose, in which the date on which the proceedings are held, the name of the employee proceeded against the charge or the charges, the evidence on which they are based, the explanation and the evidence, if any, tendered by the said employee, the finding or findings with the grounds on which they are based, and the order passed shall be recorded with sufficient fullness as clearly as possible, and such record of the proceeding shall be signed by the officer who holds them, after which a copy of the record shall be furnished to the employee concerned, if so requested by him in writing, my lord.
This is a record of proceeding before the inquiry officer.
Now, my lord, once that record of proceedings, I am not on that. I am absolutely in sync with the inquiry officer's proceeding, my lord. I am.
You have not challenged the order of the Honorable Single Judge. So therefore, till the stage of submission of inquiry report, there is no dispute.
No dispute. No dispute. In
Thereafter.
fact, I concur with the findings of the inquiry officer because it is not proved against me. I am seriously aggrieved.
One charge partially proved.
Partially proved, yes. For that, it will be a minor misconduct. I have already suffered. I am not in service. For the last 10 years, 9 years, I have been suspended. I have been thrown out of my service. Suspended, আমার termination কবে হলো? Final order. After the final order, my lord, I have been terminated. I have been dismissed from service, my lord.
Must have been, yes.
And my lord, since I am dismissed from service, my lord, none of my benefits are now coming forth, my lord. And this is really the situation I am in. And I still want to go back because if I feel, my lord, if your lordship considered view, my lord, I should go back and fix the bullet, my lord. I might as well do that, my lord.
No, but you have no option. That's why we are saying you have not challenged the order of the single judge.
I have
To
not.
go back.
I have not. I have not. Because, my lord,
unless they get something better from us, you will have to go
but in the stay petition, they have not even taken these points, my lord. I will.
Which point?
None of these points, my lord, what my learned friend has argued, my lord. Nothing has been taken. Why they have aggrieved? Kindly see, it's a 10-page stay petition, my lord.
Because it cause prejudice.
Bank misconducts, etc. My lord, charge sheet appears para 4, dishonest intention. Para 12 and 13 is what they have actually said. It is stated being agreed by the say judgment and order unless operation of the order is stayed, etc. This is their main pith and substance of the stay
because the penalty is gone now.
Maybe, my lord, maybe. I have not challenged because, my lord, it was
Fair enough.
meeting, my lord.
You have accepted whatever has happened to that proceeding.
Yes.
That is your bona fide stand. There is no problem with that. You want to face the consequence for that, you will face it. But regarding the remainder, we are only so there is no provision akin to that clause 10 of the regulation.
Yes.
So then you have Kunj Bihari Mishra judgment.
Sorry, my lord. কি বলছিস?
Punjab National Bank versus Kunj Bihari Mishra judgment.
I will just get
or any other judgment you may rely upon. We are not.
Kunj Bihari Mishra.
In the case of disagreement, the law was elaborated in that judgment. Therefore, we are saying.
That's 1998 Supreme Court, my lord. 2713, my lord. Also, my lord, 1998 7 SCC 84. I'll consider that, my lord.
1997 SCC. 1997?
I'm sorry, my lord. 1998 7 SCC 84.
Place the relevant part tomorrow. We can confirm.
Fair enough, my lord. I'll come back. I have one also tomorrow, my lord.
If they want to make a reply, we'll give them 5 minutes. And 10
I have the FTI matter also fixed tomorrow, so keep it back to back, my lord. I will do it at one go.
That is adjourned. Just have a look at the settlement. If you can pinpoint, we could not go through the entire thing.
Well, I will.
Whether there is a specific clause dealing with this stage of the inquiry.
I will come back on this. Grateful, my lord. Well,
you also, sir, have a look at the settlement if you can find that.
I can.
Chief Mr. Rameshwar Sinha appearing for Union of India. I am praying for not today.
Let's see. Intra-court appeal. Filed within time. Yes.
So this is the case. Malad, the appellant was a Navy personnel, Malad, on the basis of the preliminary inquiry, Malad, a summary trial proceeding was initiated. On the basis of that, Malad, the charge sheet and show cause, and after that, Malad, the punishment was issued. Malad, the first punishment was, Malad, the reduction of the rank. Second is, Malad, reprimand by the captain. Third, Malad, stoppage of leave salary. And third, Malad, conduct of good badges. Malad, that good badges, Malad, that is affect my financial conditions, Malad. This is one kind of like pay and allowance. This is good badges. When that is all been that good conduct badges, Lordship, that has been already they stopped. After that, Malad, suddenly in the year 2024, Malad, when this punishment was given, Malad, in the year 2023, suddenly, Malad, they on the basis of that punishment, Malad, I preferred a statutory appeal. After the lapse of statutory appeal, Malad, once not been received any reply from them, Lordship, I filed on one original application before the Learned Armed Forces Tribunal. On the pending of this Armed Forces Tribunal, Malad, they came, they said, now we allowed your appeal and we considered and we rejected the entire punishment with a condition, Malad, to retrial. With a retrial, Malad. On what basis they start the retrial? Without any reasons, they issued that communication letter. After that, Malad, I asked for what is the reasons, why you start this retrial proceedings. Give me the reasons. After that, Malad, once I asked for the copy, they refused to give me any copy. I asked, then you first restore me from the rank. Since it is a retrial, I don't know under which provisions you start the proceedings, because not has been anything clarified in this letter. After that, till to that is unreasoned order. So give me the reasons. They failed to give me the copy, and also asked me if that is a de novo proceedings, they please restore my rank. They said after the proceedings we restore the rank. Well, that is double jeopardy, my lord. After that, my lord, I again approached the Armed Forces Tribunal for the review petition. After filing the review petition in the month of June, my lord, they served me the copy without any reasons. On such and such, your retrial proceedings will be initiated. Till today, Lordship, I don't know what was the reasons. After that, well, in the meantime, my lord, the retrial proceeding was conducted and they dismissed me from service. In the meantime, I asked me to give me the copy. They refused to give me the copy. Give me the show cause notice. They refused to give me the copy. I asked them to produce the charge sheet. Till today, I don't know the charge. My lord, this is the entire case. Even, my lord, the dismissal order, my lord, that is also, my lord, the commanding officer signed in the dismissal order, my lord, that day, my lord, he was in the functus officio. On 18th September 2025, my lord, he released from that office. But in the month of December, my lord, they put the endorsement in their dismissal order, my lord. Well, this is the sum and substance of the case. If your lordship allow me, lordship, I will start from the.
Did you challenge the order of retrial?
My lord, that has been challenged. My lord, that is the challenge, my lord. Well, on the lord, what lordship, I am only before the lordship.
When you challenge the order of retrial, after the dismissal or prior to dismissal?
My lord, prior to dismissal, my lord, because
For the tribunal.
before the tribunal, lordships, I challenge my lord, give me the copy, because that order I know, I don't know what was the reason for retrial. Lordship knows, lordship, the
That letter directing for retrial, setting aside the earlier finding and directing for retrial.
my lord, come to page 112, my lord.
So this, according to you, is not sustainable.
My lord, since it is
See,
unreasonable.
where is 163 of the Navy Act?
My lord, 163
Of the Navy Act.
My lord.
Don't have three. One you don't have. One. This is application. One. One. You don't have one.
I only
No, there must be another copy. Ah, this is another.
My lord, at this point, my lord, I have only one copy, my lord.
Come with 2 copies. We'll proceed tomorrow.
My lord, I will come. I'm extending my apology, my lord. I only have one copy.
No problem. Let him be here tomorrow.